Ready?
Oh, yeah.
I'm actually, I was just.
As of
approved
2021
for
expansion,
the
will be automatic.
All right.
Let's get this on.
Okay, welcome everybody. Thank you all so much for taking the time to be here. It is a tough time of year in terms of breaking away from all the personal obligations that you have, and so we really, really appreciate that you made it here today. We're going to start with Mimi and the roll call.
Justice Edmond.
Here.
Toby Rothschild.
Here.
Joyce Raby.
Here.
Andrew Ruda.
Here.
Simon Bowman.
Present.
Carol Bird.
Here.
Judge Wendy Chen.
Here.
Abhijit Sivan. Abhijit, are you there?
He's not here.
Okay. Jean Clausen. Johan Drolseken.
Present.
Margie Estrada. Lori Gonzalez. Bridget Granny.
Here.
Andrew Kuchera. Joanna Mendoza.
Here.
Kevin Moore.
Here.
Heather Morris.
Here.
Alan Rodriguez.
Here.
Dan Rubens.
Here.
Mark Tuft. Angelina Valverde. And Joshua Walker. Thank you.
All right. Good morning again to everybody.
Hi, Justice Edmond.
Yes.
This is Carolyn Shining. I just want to report here, and I'll just be listening on the phone today.
I'm sorry, could you say your name again?
Carolyn Shining.
Sure, Carolyn Shining.
Terrific. Thank you so much. Okay, at this point, we're going to, as we always do, find out if there's anybody here who wants to provide public comment. Or anybody on the phone. Okay, hearing none, then we're going to jump right into a packed agenda. I don't have much for the chair's report other than to say I think you all are aware that we're really going to continue the work that you all started at the November meeting. I was sorry that I wasn't able to be there, but obviously there was a lot going on, and I know a number of you have been very busy since the last meeting, and so we expect it to be a really productive day. The only other thing I'm going to do is point you to the report that was included in your materials, as I think it was attachment A. The State Bar commissioned a report on corporate legal services. And it's really a follow-up to some of the hints that we got about what's going on in the corporate legal world from Professor Henderson's report. And this is a follow-up by a woman named Lucy Rica, who is with Stanford, and she's participated with the Utah project. And so it's a fascinating report. My goodness, times have changed since I was a young lawyer at a big firm. And I really would encourage you all to look at it. It ultimately, I think, will help provide some support for some of our recommendations, because it's pretty clear, it was, I think, pretty clear from Professor Henderson's report, but now certainly from Lucy Rica's report, that a lot of the tech focus that's going on in the legal world these days is really focused on corporate as opposed to providing individual legal services. So that's where we all come in. At that point, I'm going to turn to Randy and ask him to give the staff report. The only thing I would remind you is congratulations, you heard that our shelf life was extended. Instead of having to have our work done by the end of the year, we now have a sort of a drop dead date of March 31st. The trustees meeting is on March 12th. So I think at least in the short term, we may be focused on trying to do our report and our recommendations at that meeting. It may be that there'll be a special set because this is such a big topic on their agenda. But so now we're working toward the March deadline, and hopefully you all have seen the scheduled meeting dates in January and February. Okay, Randy.
So those dates are specifically January 10th, that's a Friday, we'll be in San Francisco. We're in San Francisco today, we're having trouble with meeting space, so while we like to alternate, sometimes it can't happen. But February 4th, February 24th, February 4th is a Tuesday, February 24th is a Monday. Those will both be at the LA building. And sort of, launching into the stratosphere, looking at the bird's eye view of all of this. Last meeting in November, we started with the discussion at the high policy level of our recommendations, what was the input, the feedback we received, what we would like to do with those options for reform that we discussed. We tried to stay away from the details a little bit, and we focused on sort of policy and concepts. And I think we made great progress on the first section of the agenda, which is the proposals for UPL exception reforms. And we're going to continue with that this morning. And my hope, just sort of a staff person's optimistic dream, is that before we break for lunch, that we might have some refined recommendations on the UPL exceptions for humans, and so for delivery by individuals, as well as perhaps for some tech UPL exception. And I think we had some good ideas that came out of the last meeting, and much appreciation to Tara and Joyce for advancing that with the materials. And in anticipation of the tech part of it, Dan provided us what we needed to know that would be special to the tech side. I didn't know what dark patterns meant when you referred to it last week, but now I know. I also provided, for the materials for the meeting as part of the staff report, some background on the triple LT consideration by the State Bar. You can learn the wonderful history that goes back many, many years, but more important than what happened before is what's going to happen next. And what's happening next is that the board of trustees will be having their planning session in January, and one of the topics that is teed up for the board is limited license legal technicians. And so while we might have some sort of licensed paraprofessional recommendation out of this, I think triple LT will get looked at, and while we don't have to be in a position of endorsing the exact Washington model or the newer Utah model, being able to say that triple LT warrants the board's close look, I think is a good thing. So I provided some of the background there. The second part of the staff memo talks about the Jackson versus Legal Match case. And with the permission of the chair,
Please.
I invite Professor Moore to just give us some brief observations on how that appellate decision, which we don't know yet if there's going to be a petition to review. I don't think the time has expired for that. But right now it is law in the appellate court, and it does affect the rules that we are looking at. Professor Moore?
Okay, very briefly, those who might not be familiar with the case, Jackson was a lawyer who signed up with LegalMatch.com to receive names. I don't want to use the word referrals, but that was the conclusion of the appellate court. But to receive names of potential clients who were seeking a lawyer in Jackson's particular area of interest and legal services that he provided, and also in his geographic area. Legal Match asserted that all it did was match lawyers with clients, that it didn't make any judgment as to the case, or didn't make any particular judgment as to the lawyers involved. The court appeared to have discounted that there had to be some evaluation of the lawyers that were on the website, and one of its footnotes, it went through that. There was a big argument that in order to be a lawyer referral service, at least this was asserted by LegalMatch.com, you had to exert judgment at some point in determining making a determination as to the type of case involved, and then also make a judgment as to the lawyers to whom you were going to refer the matter. Legal Match insisted that it wasn't making that judgment. And yet the court went through the legislative history, looking at the past problem that California had with runners and cappers, that you would have a layperson who would latch on to a potential client, who would then essentially sell that client to the highest bidder lawyer. Those were the findings of the legislature, and that was the problem that the court believes the legislature was trying to eliminate. Having done that, the court first held that, referral, even though the term refer or referral is not defined in the statute, there is no ambiguity as to its meaning, that you pass along, a third person passes along a potential client to a lawyer. The court said there was no ambiguity, that the plain meaning, you can just go to a dictionary and do that. And then the court spent the rest of its opinion supporting that by looking at the legislative history. Typically what courts do is that they would first determine that there's an ambiguity. I shouldn't say typically that's what courts do, but often, most of the cases I've looked at it, they look at the term that's at issue. They make a determine whether that it's ambiguous, and then they start referring to the legislative history to get some understanding as to which of the 2 or 3 possible meanings of the term the legislature might have intended. But here what the court did is it made a determination that the plain meaning referral, that what legalmatch.com did came within that plain meaning, and then supported its conclusion looking at the legislative history, that is what the court must have intended, the legislature must have intended the plain meaning of the word. And then in a very brief final section, the court said there was a second issue that the court had to address, and that was whether the legal match business was directly or indirectly in the referral. And the court said yes. I mean, we pretty much answered that question by our initial analysis, which took 4 or 5 pages to do in its opinion. What effect this is going to have on our work, I'm not entirely sure. It could have some effect depending on what the ultimate recommendation of this task force is going to be as to the fee splitting rule in terms of the alternative 1. I don't think it'll have an effect on alternative 1, but on alternative 2, which is the consent model, which is proposed and circulated for public comment, it could have an effect there. It could have a very significant effect. That the only way that this could be done is perhaps if a law firm were to also become registered as a legal services provider, legal referral service, or anyone who wants to invest in a law firm under the consent model, and would be a question of perhaps referring clients to a lawyer. It could get a little bit hairy, and they could be deemed to be violating the rule. The other thing that we have to be aware of, because we didn't really address the legal match services, which I think a lot of us who have looked at the development of these services, legal matching, and not necessarily view them as legal lawyer referral services, is that we may have to perhaps rewrite the exception in Rule 5.4, the exception to fee splitting, which says that you can split a fee with a lawyer referral services so long as it's certified by the state bar. Now, if a lawyer uses one of these match services that is not certified by the state bar, then that lawyer is in violation by having split fees with a non-lawyer, and it's not an approved exception in the law. So we'll see. I kind of like to say, let's wait and see what the Supreme Court, where the petition for review is filed, and what the Supreme Court might do. Concern there is that our term might be over before that happens, and we have a good idea of what's going on. So it's something that we might want to consider.
Thank you. And you noticed from the case, California is identified as one of the few jurisdictions that actually registers, certifies both for-profit and not-profit LRSs, and we checked with the appropriate staff here at the bar. We do have 44 certified LRSs, and of them, 6 are for-profit. The other part of the staff report materials is attachment C to my memo, and that is a proposed recommendation to the American Bar Association ABA House of Delegates. House of Delegates will have its mid-year meeting in February. I think it's in Texas, I forget the actual date. But this resolution could come to the House as soon as that meeting. And I encourage you to read it in the supporting report because it's directly in line with what we are doing with this task force. In fact, this task force is cited as one of the regulators out there that has inspired the ABA to encourage really the entire country to do exactly what we're doing, considering changes to fee sharing, non-lawyer ownership, and other reforms that will advance access. And I just note that it's authored by the ABA Center for Innovation, but it's supported by their Standing Committee on Delivery Legal Services, the Standing Committee on Ethics and Professional Responsibility, the Standing Committee on Professional Regulation, and the Standing Committee on Public Protection and the Provision of Legal Services. So the idea that a voluntary lawyer member organization and all of its key constituencies are supporting these reforms, I think is refreshing. I mean, based on what we got when we went out and did our town hall activity. And on that score, and it's a bit of a transition, I'm smiling at Bridget right now because the town hall was sort of an interesting exercise, but we are proceeding to also engage in some less formal, more discussion-oriented interactions with stakeholders. And these will not involve any sort of notice, it's not going to be a meeting, it's going to be more of a brainstorming session to see what we can do sort of in the aftermath of the public comment and where we are now, constructive things that might help from some of these key stakeholders. And Bridget, do you just want to mention some of the groups we might be outreaching to?
Sure, is this on? Yes, so I don't have everything completely solidified yet, but I've been working with the consumer attorneys to try to nail down a date and also legal services. And my idea is to bring, there's actually a facilitator, like a professional facilitator that works at USD who's a professor, but somebody to help, just kind of a neutral party to facilitate the conversation so that we can actually have some dialogue instead of just what we've had before, it's just like a one-way conversation. So, and then we're also, there's a couple other groups that we're kind of thinking of, we don't really have anything lined up yet.
As you get those dates set, Randy, can somebody circulate them to all us?
And in fact, we might even be enlisting, hopefully, some help from some of you on some certain things. I think we've already floated some things to Toby and Joyce. And so we look forward to that. And that is not the only bit of further outreach we're going to try to do in the short time we have for our reporters to. We are also proceeding with a survey that we had talked about earlier on that would have overlapped with public comment, but now that we are a little further along, we have a little bit better idea what we're dealing with. We are actually going to proceed with a survey. We are looking at either potentially a 10-minute survey with a fixed price or a longer survey, 15-minute survey, and the number of questions could vary based on the branches, but could be about 30 questions for a 10-minute survey, 45 questions for the 15-minute survey, and NORC is the group we're working with, and they are proposing a schedule that would be about 17 weeks to turn it around. So we need to work with them on that, and we have a small strike team that we created to look at the survey early on, so we might be contacting you. I think, Joanna, you were one of them, and there was a couple of other folks, I can't remember exactly, but as we get closer to formalizing the questions, and we're going to be relying heavily on Nort to help us develop that. We also have a staff person who is taking the lead with us on that. We'll be sure to rope in our designees from the task force to help us make sure we're asking all the right questions. really all I had for the,
Question.
yes,
Is that a survey of consumers? Is that what that is?
yes.
Okay.
And so that is all I had in terms of what I've provided, the materials for the staff report. Going back to the big picture, I am hoping we could get some recommendations out in the morning on UPL exceptions in the afternoon. We should definitely proceed with the fee sharing and the non-lawyer ownership alternative business structure discussion. Hopefully we can make progress on those like we did at the November meeting. But what I want to do is, as recommendations are voted out, I'm going to ask for the help of the key persons who participate in crafting those regulations to also go the next step and work with staff on the section of the report that would be an explanation of that recommendation. And so all of the window dressing for the report, how many times we've had, all the public comment we got, who served on the task force, all of that staff will take ownership of. That will all fall into place. But when we get to the individual recommendations, while it's still fresh in our minds exactly what we did, some of you will be asked to help us craft and write the actual sections that are expected to be provided to the board and potentially ultimately to the board, which would be the typical things. We need to do the pros and cons. What were the pros and cons of what we're recommending? Why we think it'll advance the charge of the task force, and what were the alternatives considered. And if we have that in support of each recommendation, and we could be referring to the RICO report, the Henderson report, what we saw in the public comment, our own deliberative process, then I think we will have what we need for each individual recommendation. And the final Justice Gap report, we should see it.
It's going to be published by the end of the year.
Oh, by the end of the year. Okay, so we'll be working with what we have right now, and that will also play a part in what we would hope the members and staff would use to flesh out the recommendation of the task force. And so we want to get through as much as we can today, but we have a January meeting where we don't finalize recommendations on fee sharing and non-lawyer ownership. That would be the target date to wrap those up. And then our first February meeting would likely be all the remaining recommendations. So we have a competence rule, which I hope is a no-brainer. We have advertising rules. We have Model Rule 5.7. We have the metrics and some of the other general recommendations. But if we're doing those by our first February meeting, I think we're in good shape. Again, if we're writing the supporting material for each recommendation as we vote it out, we should be able to have it in hand in time for, we don't want this to be a report that goes to the board 48 hours before they meet. We want it to go to them with a good, generous amount of time for them to digest it. So that's the big picture game plan.
So the message in a nutshell is we're not waiting until March to write this thing. Any questions for Randy on anything that he's got? Okay, so let's jump right in. The next item on the agenda is approval of the action summary from the November 6th meeting. Is there a motion?
So move to approve.
Move to approve, and Dan is a second. Okay. Me?
Angela Rita?
I wasn't at the last one, so can I vote or do I abstain?
Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang?
Abstain.
Abhijit Sivan? Jean Clausen?
Abstain.
Oh, thank you. Thank you, Abhijit. Jean Clausen? Johan Trolsekin?
Yes.
Margie Estrada? Lori Gonzalez? Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Abstain.
Kevin Moore?
Approved.
Heather Morse?
Abstain.
Joyce Raby?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Abstain?
Dan Rubens?
Yes.
Mark Tuft? Angelina Valverde? Joshua Walker? Thank you.
To be clear, you can vote to approve minutes even for a meeting that you were not in attendance.
Oh, I didn't know.
Yeah.
Okay.
You can do whatever you'd like. I just want to make sure that you're aware of that.
Okay. The first item on the action item agenda is the discussion about the UPL exceptions that you started back in November. I'm going to, at this point, turn the floor over to Joyce and to Tara and let you all make this presentation. I'm gonna
I'll
start.
let Joyce.
Is that okay?
Yeah, I got your back.
Yeah, cool. Tara and I did meet a couple of times in between November's meeting and today, and the result of our work has been summarized by the staff and is located on, starts on page 97 of the materials if you want to look at it. I know it's a lot of new stuff, or a lot of, it's a big document to have to wade through. What we wanted to accomplish a couple of basic things. We wanted to come up with language that would support the expansion of services by individuals. Given the current regulatory environment that allows for document preparers and legal navigators and other such, like what could we do to sort of expand those roles with an eye towards increasing access to justice? And then I think the,
No, you're fine, it's just exactly.
oh, okay.
You're perfect.
And the second thing that we really wanted to do was also to not leave out technology. We felt like that was another area that we wanted to ensure that in this first round, or at least in our discussion, got included, because we felt like if we came up with some sort of a structure that allowed us to expand the ability of individuals, that same structure could be used to allow for technology companies to provide some services. So we laid out these tiers. First, tier 1, tier 2, and tier 3. They are sort of varying, varying and increasing as you go up. So, tier 1 is sort of a basic, there you go. Here's some basic activities we think fall within tier 1. Tier 2 allows for those activities plus some additional areas of responsibility. Tier 3 deals specifically with technology. And I'm not going to read through this, though I certainly can if you'd like me to. But I think that if you accept sort of that basic structure, there's a couple of caveats. One, we absolutely said that that all of these activities should be limited by practice area, and those practice areas should be selected and informed by the Justice Gap Study. We weren't really interested in just sort of opening it up whole hog. We were definitely focused on those areas where we felt like there was greatest need. So that's the first caveat. The second caveat is we did not have the information provided by Dan, which I know he's going to review here in a minute, which I found to be very helpful in thinking through what we would have to do in terms of regulating technology companies, in terms of what they, I felt like there was a lot of specifics information that could be used to inform that tier 3 and make it much more specific than what we had, but we didn't have the benefit of your expertise at the time that we were meeting. But I think it can certainly be incorporated into. The initial stuff that we sent out was reviewed by Kevin. We did accept all of those comments, and Randy, I think Randy had also submitted some additional commentary that we incorporated into this when we met the second time. The last caveat that I think is in here is I know that we don't specifically talk about LLT. And in the pre-executive team meeting just before the thing, there was kind of a conversation about that. And I wanted to be clear that that isn't because we don't think the LLT program isn't a viable thing that should be reviewed and perhaps considered. I think that in Tara and I's conversation, LLT, everybody has sort of a preconceived idea about what that means, what kind of activities are allowed. I know that when we had Julian Hatfield here, she said, just forget that. It took Washington State 15 years to do. It's too expensive. It's too, restrictive. It's blah, 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 blah. We just didn't refer to it specifically as a way to sort of bypass some of that baggage, if you will, around that term and around that language. We were sort of saying, there are clearly some activities being done by non-lawyers right now. We could expand that to allow for additional responsibilities and additional assistance, and that really we can do that without necessarily having to walk down a very sort of specifically defined LLT pathway that we just didn't think was, necessarily useful. And Tara, if you have something you'd like to contribute as a co-author and as the one of the only lawyer between the two of us, I should probably give you a chance to say something.
Just as to tier 1, you said that we were narrowing subject matter, and I think tier 1 was a little less narrow. And that also borders really on access to information, which some might argue, well, you're just giving information, and we've kind of had that discussion. And I think a lot of companies feel, at least again, based on what we've heard, a lot of companies feel like, well, it might encroach on UPL. And so what I think we were really looking at as tier 1 is we want to make information to legal information more accessible without that being a UPL violation, and these connecting the dots for people.
Because we wanted to cover procedural things, processes, so that you could say, here's what you can expect in terms of what might happen next. And I think sometimes that can be specific to a case, and so that's, I think, where the line gets blurred, right?
Yeah, and I think another example was going to the family law person who says, well, these are all the family law forms, but doesn't tell you which one to use.
Right.
What's wrong with them saying, well, look, I'm not a lawyer, but these are the forms that you should use. I'm sure we can make guides, for all of these things to assist people, but it should be more than just like, well, here's the universe of forms, good luck.
Yeah.
It should be, well, this is the box that you might want to check. Again, with the disclaimer that, this is their experience. And with the LLTs, just to reconfirm what Joyce said, is that one thing that I was really concerned about is that we do not want to create a whole new education structure. It seems like that is really part of the failure of Washington, and in other areas of practice we've seen that, like in the medical field, where you have all these texts and stuff, but there's only so much schooling that can be offered for everything. So we didn't want to limit it. We really we didn't want to pigeonhole ourselves into this preconceived notions of LLTs. We want to use what we already have, expand the opportunities we already have, and that goes back to sort of our list of these experienced professionals that are already in our system. How do we, maximize the use of paralegals that we already have? How do we maximize the use of maybe, document prepared, maybe, build from that, or JDs or licensed professionals from other states? How do we make more opportunities for people? And so I think not using the term triple LT is pretty important in my opinion. That's it.
Okay, let me turn to the two of you and ask, should we go to tech and get a brief description of that before we talk in detail about this, so that we've got that background?
Well, there's two. I just said yes, and then I'm going to qualify that. If the group thinks that both individual and tech should be included in a single thing, then yes, I would suggest that we go to Dan, because I think that's probably really more of the meat that needs to be described. Is that fair? Do we want to ask the question of whether tech and individual expansion should be included in the same recommendation, or do we want to split those two things out? I would like maybe a straw vote or something, just to kind of get maybe quickly.
I suspect in terms of voting it out from this group, we ought to separate the two. But just in terms of the discussion,
Then I would.
we probably ought to get the background from Dan, and then we'll turn back to the human side.
Cool.
And then talk in greater depth about tech. Dan.
Sure. So I put this together in the form of a whole recommendation. I'm not sure if that's what it will take in its final form, but I'll just go ahead and read out the actual recommendation and sort of the headlines. And again, this is just me putting something together and Bridget reviewing it. So technology providers engaging in authorized practice of law activities must comply with both existing law and best practices. Obviously, you have to comply with existing law. That's not really the question, but best practices. So that gets into things like accessibility, and we'll talk about that a little bit more. Technology providers must work to mitigate or eliminate bias and other negative effects when deploying algorithmic systems. So build a system that floods the courts with thousands of lawsuits, because that would be bad. So think about the greater societal impact when you're developing algorithmic systems. As far as accessibility standards and sort of best practices, you already, when you build a website or an app or a service, you already need to meet accessibility guidelines The ADA says that you do, and there's some recent case law that opens up a whole sort of new sector of litigation, apparently. Again, not a lawyer, but that's what I understand. If you're not meeting basic accessibility standards. The sort of gold standard is Web Content Accessibility Guidelines 2.0 level AA. That's what's recommended. You might see something else called 508. That's section 508 of, I think, ADA. That doesn't really apply technically, but it's generally considered sort of the right standard to shoot for, and that recommends WCAG level AA. So that's just sort of the minimum baseline for if you're using a screen reader, you can get access to a website. The whole idea is we don't want to provide sort of a tier of legal services that is perhaps more efficient than existing legal services, but have it not accessible to a segment of the population. That would be bad and generally violate our concept of fairness. So there's the accessibility standards, but then there's also sort of the harder to put your finger on portion of that, which is user experience. And user experience is that covers things like using accessible language. It may not be in the official WCAG guidelines, but which covers things like color contrast or tags that screen readers use. But by using things like accessible language, again, in legal, that's a pretty big thing that we're all aware of. You can make your technology or website or service accessible to a broad population. I think that's a good example, but there could be more aspects of user experience that the regulator eventually hits upon. I think that the important thing is, since this is technology, this needs to be flexible enough to change over time. The regulator needs to be able to propose and implement new regulations. They also need to, and at the end of this, I talk about this, they need to be able to enforce this. So they need to be provided with the authority to, and the funding, very importantly, to actually go and enforce this. There's going to be some technical skill involved in finding the companies proactively that are violating such standards, and they'll need some technical expertise to do that. I do go over a little bit of dark patterns here. There is a federal bill proposed in the Senate that sort of tries to outlaw these for very, very large tech companies. The actual wording they use is that dark patterns are essentially the purpose or substantial effect of subverting or impairing user autonomy, decision-making, or choice. In other words, it's all the sneaky stuff that tech companies do. It's the hidden cancellation buttons, the false urgency, like 38 people are looking at this flight. It's that kind of stuff it's just sort of, it makes you feel icky. It's the shady stuff that tech companies do to increase their margins. Generally, if we're talking about providing legal services to people, we don't want people to do these things. A lot of them border on fraudulent, but probably don't cross the line. And over time, there have been a lot of consumer protection laws passed in both California, other states, and at the federal level to protect consumers from these sorts of shady practices, but the law always takes a long time to catch up with what's currently happening. So just generally, we want to, I think, prevent companies that are providing legal services from doing things like this. And if they do, I think consumers or the customers, clients, whatever you want to call it, of these legal providers need to have the same kind of remedies that they would have from sort of normal or regular legal practice. So that could be something akin to a malpractice lawsuit. And as a small business owner, I'm very keenly aware that that will increase the cost of insurance. So we're adding a barrier there, and since Lori isn't here, I will play her for just a moment. That is going to be a barrier, and we should think very hard and long about whether we want to erect that barrier. I think that we should. I think consumers should have the same legal remedies as they would against a lawyer. But that's something I think we should discuss, and that will increase insurance costs. That's okay with me. And then finally, I talk about careful implementation of algorithmic systems. There have been a number of lawsuits and news lately about facial recognition and things like that. We want to be sure that we're not enabling the mass sort of distribution of harm through algorithmic systems and enabling that through the legal system. The legal system has very real effect and sort of final and ultimate effect on people's lives. So we want to be very careful when we hook up algorithmic systems to the legal system. That needs to be done very thoughtfully and carefully, and I think that's where the human side of this comes in with the different tiers and thinking about how to scale this in over time and with care. So that's all I've got.
Okay. So, Bridget, did you have anything you wanted to add?
From about what Dan said?
Yes.
No, he covered it very well.
Okay. Then why don't we go back to the discussion about the recommendation that came from Joyce and Tara, and then and discuss that and possibly vote it out if everybody's comfortable with that at some point. And
I just wanted to double click on the idea that we're going to focus only on areas that are identified as those with the most need. I think that's really important that we enable that. But I do think that oftentimes when I think of access to justice, I think of it as something that affects, lower kind of income folks all the way to middle class, and even folks who are making a lot of money by today's standards. Often we hear about lawyers who joke that they can't afford themselves. So I worry that by limiting, by just in certain areas, I think we're doing a disservice to kind of the whole nature of access to justice of our group. And why I bring that up is, if individuals aren't going to be able to get legal advice on things such as purchasing a new home or entering into a new job and having their employment contract overlooked, etc., I think that we're not actually achieving the goals of what the task force is. And so I think it's I think there should be language that says maybe there's, an increased kind of quick application process or some sort of up for individuals building in certain spaces. But I think limiting our efforts into certain areas would be falling short of our goals, because I think every American, every Californian deserves to have access to legal services, and we shouldn't say which are kind of given preferential treatment or not.
Yeah, we definitely did not want to limit it for financial. That was very intentional when we went through it. And in fact, we want to make sure that we are not overly limited. But when we're talking about really more of the tier 2, the offering higher level of services, we felt that the place to start was the most needed services based on the study. But I again, when we were discussing, we specifically said we do not want to create any sort of system that's so narrowly defined that it's only giving opportunities to these 5 things, which we have this great chart that Randy made that shows the different professionals we have now and broken down into their obligations. Did you share that with everyone, Randy? Okay. So if you haven't seen it yet, it's really awesome. The legal document assistant, the unlawful detainer assistant, immigration consultant. And when I looked at this, part of my concern is I don't want to create more unlawful detainer assistant type categories, right? So that we're all pigeonholed. So I definitely want to keep it open, but we also thought we need a starting point. So let's start with the areas of need. So that would, again, I just want to make sure that was clarified.
Something that is interesting and may address your concern in part from the Justice Gap study, we do see that the top 3 legal needs are consistent regardless of income. So we did include an unincome delimited sample in the Justice Gap study, and the top 3 are health, finance, and employment, regardless of your income. And then there are different patterns in terms of those problems for which you go to seek legal help. Those do differ by income, but the top 3 legal needs consistent, which I think is a very interesting finding in and of itself. And you notice in California, housing is not there, which is surprising. So there's a very rich data set here, even if you are going to limit it using the Justice Gap study.
So I take what you said, Andrew, is that you don't have a problem with at least starting slowly and focusing on what the Justice Gap study shows us, but that we ought to build in some language that this is going to be expanded over time and made available to more people.
I mean, I'm definitely fine with that. I just think that sometimes I feel that as a group and just in discussions in general in the space, we oftentimes almost will start with that, because sometimes saying that we're going to open things up completely leads to some waves and some opposition. And while I can respect that, I think it's important to be as bold as possible and speak about access to justice for all. And so I think starting that totally makes sense to me. But I just think in the language and in the way that we present things, I think it's important to tell people that for us, it's not just about folks who, you know, are kind of at a lower socioeconomic status. I think it's a crisis for everyone in California. And I just think it's really important that we are very clear in that message and enable kind of, the other thing that I would say is, in order for us to truly have kind of an open space where folks will want to innovate within this space, telling them where and what they can do will probably end up preventing some folks who might be able to really add to and help fix access to justice, or at least contribute to it, from getting involved in this space at all.
To provide an example of, I think what you're attempting to say, the Florida name change tool helps people change their name, but also their gender marker on all government documents. It's a huge benefit to the transgender community. It avoids, if they can have a identification that matches the gender that they present. It eliminates often a significant amount of violence and harassment, discrimination that happens on a regular basis to that community. And when you say name change and gender marker, that's not normally considered sort of falls within kind of the typical thing we think of. We think of eviction, we think of bankruptcy, we think of lots of family law issues. Those are all legitimate, high, great need areas, but I think what Andrew's trying to say is that if we say that those are the only places that you can do anything, we're going to miss perhaps some of these little pockets of very, we created an entire document assembly system that people have been using. I mean, over 70, 80,000 individual forms have been generated since that system went into place. It's obviously making a difference in the transgender community, and that is clearly a vulnerable population that we would hope that the work that we do here would ultimately benefit. But I think that's a nice example of where not something that you typically think of as being a pretty significant need to a particular population has a very great benefit, and we wouldn't want to create a system that precluded the ability to create a tool like that.
That's a great kind of summary and a great example of what I mean.
Have we ever looked at what services lawyers in California are not providing? So, I mean, going back to what you're talking about, Joyce, is that I'm looking for an attorney who can do that, and I cannot find a lawyer in California who will just take on, because it's a couple hours worth of work, it's not worth their time, and nobody is setting up practices to handle this type of legal work. So to me, going back to, Andrew's point, is that there are services in California that we cannot find lawyers to do that work because it is not cost effective for a lawyer to set up a practice to do that type of work. And so
it's not covered by legal services either. So
Correct.
It's not something a legal aid organization typically does.
Correct.
Right.
Wendy.
What comes to my mind is the entire realm of limited jurisdiction litigation, which is the 25,000 and below,
right,
that it is above the small claims marker. that little gap right there, and there's a lot of litigation in that gap, and no lawyer wants to take that. Well, some do, but it's very hard for them to do. So you get more than 2 court appearances, that's it. It's not worth it to them anymore.
Neil.
And following up on what the judge was mentioning too, maybe also throwing the idea out there, just speaking for myself, maybe also allowing court appearances in some of those matters for this group.
And then I just wanted another thing, not just Heather, what you mentioned in terms of where there aren't lawyers, but I also think that we might have to accept the idea that there might be ways that legal technology, as well as certified professionals using kind of that same chart there, would be able to do things that lawyers are currently doing, but at an affordable rate, and they might bring an attitude of innovation and forward-thinkingness that currently is lacking from the practice. And so I think us only going where there is so-called most need will end up actually having us miss out on some really valuable innovation, as well as I think us shying away from saying that access to justice is a crisis that affects everyone, regardless of kind of how much money they make a year. I think that is something that is really important that I think as a task force we have to keep in mind. So yeah, I think the way that I see things is there might be a future where you could end up talking through with a piece of legal technology, and I think Dan did a tremendous job in outlining some of the really kind of moral and ethical things that we definitely need to include. But even with including all of those stipulations and regulations, I see a world where almost like a TurboTax approach to a lot of legal issues can be deployed, but that might actually be things that lawyers do right now, but most folks can't afford to actually pay those lawyers to do. And if we study them and we see that the outcomes are positive or at the same level, if not better than what currently is being provided, I think we should be able to support those initiatives.
Toby.
I agree with that, but let me back up just a little, and that is the talking about changing the world, and the question is, do we change it all at once? Do we have the capacity to regulate everything all at once, or are we better off starting small, starting with the greatest needs, dealing with those, testing out models, testing out systems to make sure that it's going to work before we open it up to broader and broader and broader. And in terms of your comment that it ought to cover everybody, I think there may be some levels of income. And I think Jeff Bezos doesn't need help with access to justice. And
I think Jeff Bezos is probably getting ripped off on his legal services.
I think he has the resources to address that if he wants.
I agree, but I don't think the market as it stands is a fair market for anyone.
So I'm gonna jump in. I really hear what you're saying. So what I'd like to do is, and I don't know the formal, so I'm just gonna say it and then you guys can inform me the formal way to do it. I think that Tara and I would probably consider a recommendation to modify what we put together to include the idea, some language that says, we'd like to baby step our way into this. We'd like to start with these particular things, but that our recommendation doesn't preclude expansion into other areas. At such time that the state bar and whoever blesses the Pope, whatever you got to do to make it happen, right? Like I think, like Tara, you're shaking your head and smiling, so I'm assuming you'd be totally okay with that. And I think if that's something that we would be willing to take on. And if we could include that as sort of a modification to the thing, does that make sense? I know that was a really technical statement.
Modification to the thing.
To the thing.
Okay, for me to accept that as an amendment to
Yes,
what
ma'am.
I'm here to be your motion. Okay, Dan.
So I think on the flip side of what we're talking about here with the human sort of the tiers and whatnot, just to mirror that on the technical side, I think we want to be careful that we thread the needle between services like TurboTax that provide a sort of or document assembly services, things that we think are generally good and provide a legal service that's good for the world, versus something that is more like a copyright troll, a patent troll. So we want to thread the needle between those things, and that's sort of what I was going for without explicitly stating that in the document, but I'll just say it out right now. We don't want to enable an entirely new class of patent trolls that use the legal system to the detriment of society.
Randy.
So I think I mentioned before the historical consideration of multi-jurisdictional practice as sort of a paradigm for us. And so when the Supreme Court's Advisory Task Force on MJP did their policy report and then their implementation report, it floated the topic of not just out-of-state attorneys practicing law in California, but also foreign licensed attorneys having some MJP ability. And in those reports, they made clear that we want to start with lawyers from other states because we know they went to school that teaches English common law just like us, but it's not a dismissal or a rejection of foreign MJP. It's just that that's where we want to go first because this is a big reform. Having said that, we still don't have foreign MJP, but I think the idea of what Joyce was alluding to, what I hope will make Andrew happy, is that we have to say that if there's something we're not endorsing now, it's without prejudice to that. Now, there's another way you can go about it, and to me, it's kind of like the Utah approach. If you want to go big to start, then the trade-off is it's probably going to have to be a sandbox. It's going to have to be something that is more controlled, more time-limited, more restricted. So maybe you want to start with something that says you can do almost anything, but the trade-off is it's going to be more closely regulated, monitored, and tested before it's opened up to the world. But if you do what Toby is saying is, let's start with something smaller. Let's prove we can do it on a permanent basis. And then that is the opening for doing more. Then I think you can sidestep the whole, some people don't like the idea of pilot and sandbox because it's too tentative, too contemporary. But I think the trade-off there is you're starting small, but you make clear, like in the MJP reports, that it's not with prejudice or rejection of anything else. It's just that in order to do something now and make it happen, we're going to start small.
Simon, did I see your hand?
No.
Andrew.
Sorry, it was mine. As we talk about revising and voting on things, I just want to be clear if we're revising and voting on the drafts that the staff wrote that were emailed out more recently, or the original drafts that Joyce and Tara and Dan prepared.
Yes.
Sorry to prematurely get
No,
back,
that's a very good point. I think the two things we're looking at are the December 2 memo from Joyce and Tara and the December 11 staff report where they actually came up with the language.
Right, there's also a December 3 memo from Dan.
Yes, right. But for right now, just the human thing.
Let me just mention that.
Randy.
My intent was really just to try to more formalize or crystallize the concept of what came out of the November meeting, which I thought Joyce and Terry did an excellent job with, but I wanted to sort of feed into a bit by making it a little bit more concrete and specific. And so if we're looking at a tier 1, as we're calling it, where it's taking what people can currently do, bumping up the scope of services, maybe concomitantly bumping up a little bit of the regulation, but saying we've got a lot of folks who are non-lawyers who are doing some things, and we heard about it when we went to Sacramento from the legal document assistance groups who are out there. If we could do one extra step, which is tell them which document they need to do, we could be serving a lot more people more effectively. And so that tier 1 concept is take existing non-lawyers and enhance what they're doing. The tier 2 is, well, maybe have something that is not based on the existing non-lawyer providers, but would be a potentially new thing. You don't have to label it triple LT if you don't want to, but they would require a little bit more thought, a little bit more development, because they would be something that we'd have to create some sort of regulatory structure around. But it was really just to say that there's a tier 1, and if you wanted to restrict tier 1 to just legal information, not practice law activities, that's cool too. But this whole idea of tier 1, tier 2, and then the other thing I got up in November, which I tried to crystallize, is that I thought there was a consensus that if we finally decide for humans what is tier 1 scope and regulation, what is tier 2 scope and regulation, then we ought to be able to say for technology, we can replicate that and only adapt it to the extent needed, as described by Dan, to cover the tech side. But in terms of the scope of services, the type of remedies or enforcement side, we try to mirror that. The only difference is that we're saying there would be a tech way of doing it without humans or with humans, but primarily delivered through technology. So I wasn't saying you need to pick from the staff memo or for Joyce's memo. I was just trying to make sure we have an understanding of the concept. And then once we have the concept, I think we have to put stuff on the screen and work through it. Because we want to make sure the issue that Andrew raised is covered. And what Neil said about not having some sort of implicit limitation on it being non-court appearance work also is covered. And all of that, I think, is wordsmithing. I think we have to just write it the right way. As long as we're cool with the concept.
So Andrew, I'm not sure if that answered your question or not, but I think what we would be doing is essentially moving the recommendations that are in the staff report. Recommendation 1 would be tier 1, recommendation 2 would be tier 2, and vote on that, although we're not wedded to that language necessarily, because particularly, as Randy points out, it becomes more fulsome as we have this conversation around the table.
That makes sense. Just a short follow-up question. Are recommendations 1 and 2 then, Randy, are those an either or is it a possibility that we could vote and adopt both of them? And then recommendation 3 would be a second layer on top of either 1 or 2.
Yeah, that's what I was trying to refine from the November meeting, is that even in the board strategic plan, it refers to paraprofessionals plural. And so we don't have to have a one human UPL exception thing. We have more than one. And so I think what I got out of November was that there could be a tier 1, there could be a tier 2, tier 1 building on existing regulation, tier 1 being perhaps the new thing. And so both could be voted out. And then tier 3 was this sort of epiphany we had last meeting where we said, we don't have to create out of whole cloth something for technology. We could say that whatever reform we're making for human delivery can be done technologically. And as long as we say we want to allow the same types of starting point, scope of services and tasks with the same type of limitations, but add on what is necessary for technology, that I thought that was a streamlined way of getting the tech part of the UPL exception covered. So my concept was there could be 3 things.
Can I also just offer a huge thank you to Tara and Joyce and Dan and the staff for distilling all of that, because I left the November meeting rather confused about what we were doing and what we had just done, and this is making a lot more sense now, so thank you.
Well, here. Thank you very much to Joyce and Tara and to the staff for pulling this all together. So let's give them a round of applause. So Andrew, I think the answer to your question is that we could vote out 1 and 2, and in fact, I think it's the recommendation of Joyce and Tara that we do both, as opposed to just choosing one. But everybody can obviously vote their own conscience. Yes.
I think I'm a little confused about the tiers and the recommendations. So is tier 2, as you have it here, in Joyce's memo, is that, even though you don't want to call it triple LT, does that line up with Randy's recommendation too? And in that case, is that not limited to the existing, not paraprofessionals that already are in our regulatory framework, or are you suggesting we expand the existing people in the regulatory framework, like the document preparers, and give them an additional level of responsibility, but only existing people? That's what I'm confused about.
I'm confused too. Wait. Okay. Are we voting on out Joyce and my language or Randy's language?
And if so, where is Randy?
I don't think we're at language yet.
Yeah.
The concepts as they're written are, I read them differently.
I also read them differently.
And I also don't understand, so then this makes me confused about where we are. Are we, I was confused.
I think the easiest thing, Justice Evan, would be to start with the tier 1 concept, which I think at its basic level was, we don't want to create a new licensee. We want to work with what is in the current law, but consider what types of expansions might be made in order to optimize the delivery from those non-lawyers and see if there's support for that, and then we can write something to that effect.
I'd also like to work, no offense, Randy, but from Joyce and I, from
That's
what we
absolutely
put
fine.
together, because there's less words in it. And it, yeah, that's really because there's less words, and I think it's easier to focus on it, and I get that we can build it out later, but keeping it simple.
And I think the other piece to remember is when we were talking about it, we were really focused on activities rather than specific categories. We wanted to be able to say people could do X, that they could say this is the form that you need. And, you know, wow, look, based on the fact that you have 21 foster children, you might want to consider, you know, X kind of thing versus Y. You know, those kinds of activities that are sort of built in. And so I think some of the, you know, wanting to say this was built off what current capacity we have versus an LLT program versus something for technology, I think that's a little bit of an artificial overlay. I'm not sure that I envisioned, and maybe Tara disagrees, that that's the way we were thinking about it. We were thinking more like we want to open up what people, a current document preparer could, within this framework, expand their practice to include activities outlined in Tier 1. They could also determine that they were going to go for Tier 2, and based on what the implementation body who comes after us decides are the educational and other requirements that go along with these 2 tiers. See what I mean? They could go down either one of those paths.
And I guess to
Fair
what
enough.
I hear Bridget saying is, and we are in both of those, Tier 1 and Tier 2, sticking with the existing types of
Yes.
providers.
Yeah, providers. So I think it might also be helpful to let everybody who wasn't at the last meeting sort of know how we came to this, which is that Joyce was up there leading this amazing group of people, and we literally whiteboarded all of this, and it really evolved based on our priorities. We would start by saying, well, this is a service. And then we'd be like, no, that's the wrong word. And I mean, that happened like 5 or 6 times before we really, amongst ourselves, came to figure out what our priorities were. And what ended up on the board, and I think became part of these charts, was we were focused on the activities. What are the activities that people can do? Like, what is it that we want? What services do we want them to be able to offer people? And so when we developed our summary proposal, that's really how we, in our mind, broke it down into what are the activities they can do. And then our question was, well, where do we draw the line? Where, we haven't really drawn a line, sort of maybe going to court and advocating. But even then, there were some, well, can you walk somebody into court? Can you sit next to them? So we didn't get that far. So that's why, in our mind, the Tier 1s were those activities we want really open. And also, it's scalable with the likelihood of risk. So giving information out, that's low risk. The more specific advice, the more it becomes advice and the higher level, higher risk, so that becomes more Tier 2 level activities. And those might be more subject matter focused. Someone who has a more education in family law, someone who's offering UD education, and that might be different than these Tier 1. So I think that's just kind of important to look at because those of us who are here, struggled all day to come up with all of this, and then we just sort of distilled it.
Kevin, and then Mia.
Yeah, correct me if I'm wrong on this. So I think there's going to be a lot of corrections coming down the pike. It seems to me that Randy's recommendation number 1 encompasses, or should encompass, both Tier 1 and Tier 2. Is that accurate?
Could you point us to what you're looking at?
I'm looking at the December 11th.
Yeah,
What
State
page
Bar
of the-
staff memo.
What page of the materials is it on? That's where I get.
So it's not posted, it's not posted.
It was just email.
It was an email document and.
Oh, it's not in the.
Okay, who doesn't have it?
Yesterday, right?
Who needs it?
Leah,
Oh, go ahead.
Okay.
and then Randy, I,
So I have just a question as well, or a comment. Under tier 1, now I can't find it, but we have identifying a legal issue. And I think that right now that is considered to be the practice of law, to make a determination that something is a legal issue. It's really important, and we know that from the Justice Gap study, that's the main reason people aren't seeking legal help, again, regardless of income. They're not sure that the problem they have is legal, so we definitely need to figure out how to help people do that. But I just point that out that that's interesting as a tier 1 activity. And then another question I have is, in the UK model, right, there are certain activities that are not regulated at all. And what I'm curious about with tier 1 is, are we thinking that they all are going to be regulated? And you're meaning because someone who's licensed and therefore thereby theoretically regulated is going to perform that, whether it's an LDA, EDA, whatever it is. Or are there some activities in tier 1 that we're thinking would not be regulated at all? And the one that I think of there is connect the consumer to resources. That is many people do that regardless of if they're lawyers or not. So those are 2 questions I have. One is the problem identification, really important, but right now that's definitely considered legal advice. And then connecting the consumer to resources, do we really need to regulate that?
Well, in my opinion, connecting them to resources would be like Legal Match, because people call all the time and they're like, oh, I have this legal problem. I'm like, why don't you just Google San Diego small claims, problem solved? But somehow, they have to go through many attorneys before someone gives them the Google search terms to solve the problem. And also people don't know what kind of lawyer they need, so they call these hotlines and they're like, oh, I need a consumer attorney. And I'm like,
so connecting people to legal resources, not like here's your social services agency or here's.
Well, I guess whatever their need would be.
Okay.
so Kevin, I think we left you.
You left me, but I remain uncorrected. Okay. Now, I want to go back to, everyone has the December 11th, but let's look at the December 2nd, Joyce and Tara's, which I think is what we wanted to use as the spring point for the discussion. I'm looking on the first page, it says Tier 1 activities, go down, it's the bullet points that are listed. But that contemplates the use of existing regulated certifications, ones that already exist, and they list paralegals, document preparers, and scary as it is, law schools. And so here you have this, maybe these are law students, certified law students, I'm assuming that's what that's referring to. Right? Where you mentioned law schools, are you referring to certified law students under?
No, we're saying we want to use the existing curriculum. So we don't want to, a curriculum would probably be the better word. Under the Washington Triple LTs, a big problem, like I mentioned a few minutes ago, is that they don't have the curriculum to support the programming. It's all new curriculum. So we're saying, look, we already have law schools. They need people to go. They could have entry-level type courses, the 101 courses, maybe that's enough, right? You don't need 2 years or 3 years of law school. Maybe it's a 1-year curriculum or a paralegal type. Again, not implementation, but that was the idea. Use what we have. And it could be law students.
Okay, are you contemplating as someone who went to law school for a year and maybe flunked out or decided to leave, then would be,
No.
could be certified?
No, we're suggesting that it could use the existing curriculum structures we have to create something new, but don't force, law schools to go create a whole new triple LT program. Say we're already offering these courses. Maybe they can take family law, a family law course at the law school to become a family law provider. Again, I'm not the implementation body. We're just suggesting don't go create something new. We already have these resources out there. We already have professors. We already have law students. We already have mentors. We already have recent graduates. I was talking to someone who said, we could create incubator, like the school, they're already creating incubators, but the schools we could expand that type of programming to offer pro bono or low bono services in exchange for, discounts on your tuition, that kind of thing. The law schools can do a lot because they can receive financing that can help fund these types of incubators. So that's all our point, is let's look at the resources we already have. How can we make them better? Not let's go create something brand new from the ground up that's not going to have funding and support.
Okay, I admit I didn't get that at all. It might have helped if your memo had a few more words.
I thought you could read my mind.
What was going on? Okay, but you're using that, and then you have tier 1 services, but you're also, are you also contemplating, because then you go down to the penultimate paragraph, next to last paragraph on the same page, the first page of your memo, you refer to tier 2 activities. Are you still within this concept of using existing resources?
Yes.
To provide the tier 2?
Yes.
And then tier 3 is just, there we're talking about Dan's world.
Yes.
Technology. Okay.
So
I guess what I'm looking at then is, if we go back to the December 11th memo, Randy's, which has more words, I think perhaps it would help to flesh out a little bit as to what it means to use existing resources there. That would be recommendation 1. But recommendation 2 is not necessarily something that is in your memo. Right. Recommendation 2 is regarding actually setting up a limited licensed legal technician LLP type program or regulatory authority or something that would go beyond it. But that the recommendation 1 wouldn't be limited to the 4 bullet points on page 1 of the December 11th memo. In other words, your concept of using existing resources is not limited to the 4 bullet points, because it also encompasses tier 2 and a possibility of providing legal advice in limited areas.
correct. So as an example, when I look at the chart of professionals and it shows paralegals, we know that paralegals get a lot of education here, and but they don't have any background check, they don't have financial responsibility, they don't have special filing, but they require attorney oversight. Maybe there's an area or a way that professionals who they've already done most of the hard work, go get the background check and some financial responsibility, maybe they can offer limited scope services without attorney oversight. That might be one way to use existing professionals in a new way. And that's an example.
Okay, Heather, and then Amy.
Just, when I'm looking at it and just in the reality that, paralegals are not, right, they're not licensed in California. There are a lot of different ways to become a paralegal or a legal assistant. If we're trying to open this up, to me, when I'm reading this, we're tying the person who's trying to do a service here back to a lawyer. In some way. So if you're looking at a document, someone who is trying to help consumers to identify their type of legal problem, if it's handing out forms, the way I'm reading this, that individual is now tied back to a lawyer, because if they're a paralegal or a legal assistant as currently defined in California, they're under the supervision of a lawyer. So are we just back at the same problem? To me, if we're trying to open it up, I don't.
Well, my thinking again would be that would just be one.
Right.
That'd be one thing, and so again, that might be the tier 2, that's like the inner, maybe we're opening up tier 1 really big. Maybe there's no regulation over it, and maybe tier 2 is less open up. With less overhead and less responsibility.
Joanna and then Bridget.
Andrew, I think you had first.
Oh, Andrew.
I just want to say I really like the idea of expanding the things that existing actors in our system could do, like law students and paralegals. I think there's huge efficiency gains over creating a brand new system for triple LTs or something similar. We already know from some of the jurisdictions that have done triple LTs that complexity is a large contributor to failure of a system like that. And as Tara says, we already have a system where law students can go do XYZ. They can go represent litigants in court under the direct supervision of an attorney. And I think it would be much more efficient to look at that system and say, well, if we're allowing them to do that, it wouldn't be that difficult to just allow them to do, ABC in addition. Because I think that in the end is going to be much less complex and much less chance of failure.
Okay, Joanna, Bridget, and Toby.
Well, I like the idea of expanding some of the existing structure. These are people that we don't regulate right now, and DCA doesn't really regulate them. And while I would love to see them be able to do it, there is absolutely no way politically we're going to get DCA to enforce these things. They don't have the resources to do it. So we could actually be putting the public at greater risk. Yes, there's certainly services that they should be able to offer, but unless we bring them under a different regulatory structure somehow, there's really no way to protect the consuming public for the additional things that they're going to be able to do. With respect to triple LTs, this has been obviously something the State Bar has been talking about for decades, wanting to do for decades, and the board would like to do. So an a la carte menu perhaps is the way we recommend all these different options to consider implementing. But I don't think we should be saying, no, don't do a triple LT program. How stringent it needs to be, that's up for the next body. We can present outlines for regulation that we think should be considered. But if we want to expand the existing folks, have additional things they can do, I think we need to do it under a different regulatory structure than the existing one. It's not as simple as we're suggesting it is.
I second what Joanna says. I think it's because I'm probably just more steeped in licensing and the way licensing works. So Randy's chart is so helpful, I think, because when you look at it, you can see the different things, the different ways that people are regulated right now. So, well, in theory, I think what you're saying makes a lot of sense, like why reinvent the wheel when we already have these existing categories. But the problem, as Joanna said, is, well, and Heather pointed out, paralegals right now are not regulated at all. The other ones are just merely registration, so there is no licensing scheme set up right now. So to have to do it the way that you're suggesting, which I can appreciate why you're thinking this in this line, but I think it might end up being more complicated because then if you're expanding what you're allowing people to do, you're gonna have to up that level of regulation. So then you're gonna have to change all these different categories when you're talking about the same activities, if that makes sense. So to me, because I don't think this concept of triple LT, well, I realize people have had concerns in other states. I don't interpret it as being that controversial. I feel like it's kind of generally going okay. If we don't have to call it that necessarily, but I think it makes more sense, to your point earlier, Leah, like when you're looking at activities, you can have tiers of regulation that way. So you could have maybe a certified person that can do these activities, but not try to shoehorn it into, landlord-tenant person or immigration consultant person, but just if you are a certified person, you're allowed to match people with resources, you can give them this information. If you're gonna be a next level up where you're giving legal advice or possibly appearing in court, then you're gonna have to have this level of regulation. and we're gonna have to set up a regulatory structure no matter what. So to me, I think it makes more sense to set it up by activity than by like these existing narrow categories.
Yeah, like a document preparer could actually tell you what documents you can fill out. If they would fall under this licensing scheme at a certain level.
Right, and maybe registration is fine for that level.
Yeah, but it would still be regulated. Their registration for being a document preparer would still be with the DCA, but we could give them this additional title if they complete certain things, and they would be under the program.
Isn't that what we proposed, or is there something different that I'm missing?
I'm interpreting what you, and it could be just my brain having a hard time with it, because I'm looking at these in like statutes, you know, so you have this statute for document preparers, you have this statute for these people. They're regulated in different ways, if they're regulated at all.
But that's not what's actually in the text of our proposal. I was just using this as a suggestion, which comes, in my opinion, comes to the same conclusion as you. So maybe we're just thinking of it differently, but I was just asking if there's something that you're like, no, like you said in your proposal, I disagree with this part.
Well, because
we could look at that.
Yeah, I disagree with the part that says we don't want to set up a new licensing or certification program, because I think we should.
I think that's the point, is there's gotta be some regulation of these folks, depending on how much regulation may depend on what tier we're talking about.
Okay, could we amend it to be that we're not looking for, and maybe just amend it to be like, we're not looking for like a brand new, I guess it would still be new curriculum, but that we really want to utilize our existing
We could certainly, I do think we could certainly add language that says we would fully exploit the current, regulatory environment and educational environment, to the greatest extent possible, being cognizant of the fact that, additional regulation is gonna be required, by someone, and I was unfamiliar with the DCA, is that Department of Consumer Affairs? So I just wanted to clarify because I didn't know what you were talking about. But I mean, I think we could add language. That makes total sense to me. I think all that we meant when we wrote it was we wanted to exploit to the greatest extent possible what we already had.
Right. We meant what you said.
Yeah.
Totally. But I see your point.
Yeah, totally get it.
Yeah, most of what I was going to say has been said, but let me add a couple of things. We talked about maybe law students. I don't know about the others of you who've been to law school. But I had family law in law school. I had real property law in law school. I would know nothing coming out of there of how to help a client with a divorce problem or how to deal with an eviction case.
But yet, if you pass the bar exam, you're supposedly know how to.
I'm authorized to. That doesn't mean I would know how to. Okay?
I understand, but that shows the fallacy of the comparison. Lawyers aren't necessarily qualified to do the same.
But they're allowed to.
But they're allowed to. We said so. The other thing is, some of these people may be at least registered with the Department of Consumer Affairs. Some of them, like landlord-tenant assistants or whatever the language is, they're registered with the county clerk, and they post a bond with the Secretary of State. There's absolutely zero regulation.
Yeah.
And beyond that, 80% of the people out there holding themselves out that way don't even have that. They're just out there and calling themselves a paralegal or a document preparation service or whatever you want to call it. So unless there is both greater regulation of those people and some way of limiting people who aren't registered, you haven't really accomplished anything because those people are still going to be there hurting people the same way they are.
Not to bring anything new to the table, but what Toby just said is going to be about 5 times more true when it comes to tech.
Yeah.
Yeah.
Okay.
Yeah, and so to follow on that, I think that's why it's really important to make sure that whatever this regulator is has the authority, capability, and funding to actually police this stuff.
Yeah.
I was just going to say, I think following up on Bridget's suggestion, and I do think we're all mostly talking about the same thing, I think it's really helpful to think of the tiers with tier 1 as the lowest level of regulation or no regulation, whatever that is, and then tier 2 is the next level, and then the sort of policy principle that you, to the extent possible, you want to maximize the existing infrastructure, whatever that is. Because the other population we've talked about are folks who've completed law school but not been able to pass the bar, right? There, so you have a lot of people in this universe that may have different licensing requirements. Say you've got a triple LT program and you're already a paralegal, it may be easier for you to become a triple LT than somebody just off the street. So I think if the focus on tiers is really helpful to figure out just what level of regulation is necessary, and then the principle, we want to maximize the existing infrastructure in order to be efficient in terms of developing the new regulatory framework.
Wayne.
So one of the things I tried to do, and maybe why there's more words in the version I sent out, is I wanted to crystallize that if we are regulating something, it's because it does cross the practice of law line. If you don't cross the practice of law line, do you need to regulate it? And so the giving of legal advice as to the selection of the document or the determination that your problem is legal and has a legal remedy dimension, to me, crosses the practice of law line. And so maybe anything that has that as part of what you're performing should be tier 2. And then your tier 1, if you want to cabinet, make sure it's not practice of law activity. Make sure it's just re-describing the things that aren't the practice of law in a way that takes some of the fear away from the folks who are delivering those services. So saying to the existing non-lawyers who are helping consumers that you can do the things in the bullets, but making sure you're not authorizing them to do a practice of law, because if you cross that line, I think you need the regulation.
So where are we?
Can I make a motion?
Please.
So I would like to make a motion.
I needed to write this.
Yeah, no, that's fine. And it won't be articulate, so
Yeah,
just bear with
your
me.
motion
Is for this committee to approve the creation of, for Tara and I to go back and add in to the existing set of recommendations that we outlined in the December 2 memo, to include language that addresses specifically the existing resources that we would like to fully exploit, that does some additional work around what the regulatory changes, what regulations would need to be created in order to monitor and certify and monitor activities as described in the tiers, the way they are described in the December 2 memo. Is that?
I don't think you need a motion for that.
Just, well, what I am trying to get to, and maybe I'm wrong, but what I'm trying to get to is a point where we agree in principle that we want to move forward with what Tara and I created, so that we can approve, with that, not the technology piece, but just the sort of individual piece that incorporates the discussion that we have here, so that we can end this conversation and move to the next thing on the agenda. Is all I'm trying to get to. Is that a fair thing to?
I think it is, because what we're doing is we're voting out a recommendation in principle as described in your memo with the additions that we've heard around the table. I don't see any point in wordsmithing this today.
I agree.
But it would be voting in principle to the concept of the 2-tier system with some regulation built in if you cross that practice of law line.
Yes.
Johan.
Just want to make sure to include Andrew's original statement as well about
Yes.
open to all areas.
Yes, fair enough. Thank you. Duly noted.
And is this just for individuals that we're talking about?
Yes,
Just individuals
just
at this
individuals.
point. Okay, that was the motion.
Yay, I did a motion.
And it's been seconded.
Okay.
Further discussion.
Can I make a friendly amendment that you then transmit the memo to staff to kind of polish it before we get it?
Sure.
Are you saying that ours wasn't polished?
So they can add words. They can add words. No, that'd be, yes, that's
Not
fine.
at all.
We did ask them to polish it first, just to let you know.
Me?
Are we ready?
Well, I am. Does everybody feel comfortable at this point that you know what we're voting on and ready to vote? Okay, Mimi. Yeah.
I just want to clarify.
Yes.
What you want to do is to revise, you're going to revise the memo, but you still stand by the concept of utilizing the existing resources.
To the extent possible.
To the extent possible, but also to include the necessary overlay of regulation where necessary.
Yes, sir. Tara, you're shaking your head, yes?
Yeah, we should also, what we should do is draft it, send it to Kevin.
That's fair.
And then send it to staff.
Fair enough.
Randy.
And I guess my question is, this is without prejudice to someone else making a motion that says, we want to support the board's consideration of, and use the awful phrase, triple LTs, or another new licensee regulatory ecosystem. So if you vote for this, it doesn't mean you're rejecting endorsing triple L.
I thought it was incorporated.
Yeah, I thought it was the same thing now.
I think, as a result of the discussion over here, I think the conclusion was this is pretty much is triple LT at some point, because you're going to have regulation. And it will be depending on the tier and depending on what you've identified as the activity. I think we are recommending that, but it's all one recommendation.
Right.
Right.
With subparts.
Okay, we're gonna need some help trying to make that clear to our audience.
Fair enough.
And does that accurately describe what
Yes.
was in your motion? Yes. Okay. Everybody ready to vote?
Okay, Andrew Ruda,
Yes.
Simon Boney,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang,
Yes.
Abhijit Shaban,
Yes.
Jean Clausen, Johan Trollsacken,
Yes.
Margie Estrada, Laurie Gonzalez, Richard Granny,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby,
Oh, yes, I'm sorry.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuck,
Abstain.
Angelina Valverde, and Joshua Walker. Thank you.
Welcome, Mark Tuft.
Came in late.
Quite all right. Okay, I think we're ready to move into the next recommendation. And when I say recommendation, we've kind of veered from the staff draft of the recommendations. Essentially, we just voted in 1 and 2
From the December 2.
from December 11th.
So where do we leave off on Dan's part of it? It's just gonna be integrated.
Well, that's, I
into
think
the
that's a
next-
separate recommendation right now.
Oh, sorry, I thought you meant the next agenda item. Sorry.
Dan, you want to articulate?
Can I ask a question, Dan?
Of course.
And you referred to the
WCAG.
Okay, so I guess just a very broad strokes, when we are recommending the regulatory standards for tech delivery of legal law-related services, is it your view that the task force should probably say we should comply with any applicable laws current or that would come down that would apply to the delivery of services, but there's also self-regulated industry standards. Is the current one that you just referred to, is that adopted by any law right now, or is it currently just a industry standard?
Section 508 of whatever that is, I think it's 88.
So should the task force recommend that we look beyond the law to things that aren't imposed by law yet, but are industry standards in order to up the confidence level with the fact that we're not just selling books or music, digital music, we're providing people legal advice, and so maybe doing what the law minimally requires could be augmented by industry standards that aren't yet adopted into law?
Yes, but I would say that the specific standards shouldn't be actually written down because it should be subject to change and essentially upgrade over time as the standards change. And that determination should be made by the regulator with as little bureaucracy as possible, which is why I'm saying we shouldn't write it into the law.
Okay, I was just going to the concept of we want the implementation body to look to what is legally required as well as
best practice.
Best practice, cool.
I have a foundational question.
Yes.
When we're talking about technology, aren't we in fact, for the most part, talking entities? I mean, we're talking about technology companies, and so we're talking here about entity regulation. And I don't think we can have this discussion without having a broader discussion about entity regulation. This is a specific type of entity, but are we going to allow non-attorney owners? Are we going to require that they be California entities registered with the Secretary of State or a foreign registered entity? Are we going to require, if it's shareholder owned, that shareholders recognize that certain things come before profits? And, these are issues I think that all come under entity regulation, and we can't just have technology as a software program. We have to address the fact that it's created by an entity, I would assume, and we have to address the bigger issues.
We addressed this a little bit at the last meeting. I would suggest keeping it entirely separate. And the only reason, not because it's not as easily as defined as that, but you'll have a different handhold on entities, which you'll need to establish your own standards and jurisdictions over and everything else. Technology can be distributed, white labeled, something that plugs into multiple people's sites that they use from a third party through to a user and everything else. Your challenge is going to be, at least with technology, is going to be the advice issue, and followed up with privilege and confidentiality, because we can make simple forms right now that use no machine learning and use no artificial intelligence that can function as an algorithm, as values for each answer and a path is given, but I don't think it passes as advice. I don't know. I speculate that it does not pass as advice. But because of that, because of the multiplicity of it, I would deal with it entirely separately as entities.
Can I address that? Entity regulation is essentially split into one-to-one services and one-to-many services, and the technology is clearly the one-to-many services side. And it's certainly likely to produce the greatest impact on the access to justice problem because of that. But they're both entities, entity structures, and there should be overarching concerns that we need to agree on that need to be addressed before we go to that one step further and split them out, where they have different requirements for how they do their services. So I do think we have to have the technology restrictions that Dan was talking about, but we also further need to address the overarching entity issue if it's going to matter, because you're not going to be able to do it.
You have been in complete agreement, except I'm in complete agreement, period. There's one more, which is the many-to-many. So that's what I'm suggesting makes it more complicated. Or at least
saying
makes
there's
it...
3 types, but they're still all over the same tier.
Sort of. It's who's going to have the culpability. So
Right, we need to address that.
Absolutely. And I, in the model that I suggested, entities was its own category because it needs to be done before you can even get the technology.
Right.
So I'm in complete agreement with that.
There's no point talking about technology, though, if we can't get to the entity side.
Correct.
So another reason why my versions had more words is because I sort of built into the last part of it that if there's a support for the UPL exception reform, and there's exploration and actual concrete development of an action implementation plan, then the next step is just studying the actual business delivery models. Because even with the human UPL exception, if it embodies some highest level triple LTs, then maybe those triple LTs want to band together, incorporate, and quote unquote practice law as an entity. And so there could be, implications of entity regulation even for the new human UPL exceptions. I was trying to slightly set that aside and say that if we're going to do UPL exceptions for humans, and we're going to describe what the implementation body should look at in terms of the areas of law, the tasks, the scope, and the broad strokes regulatory requirements, then whatever you let the humans do, you should also let the tech do. And if the tech can do it, it's going to have some extra things that we have to worry about, and that's what we're going to call out for purposes of the UPL exception. But there's going to have to be the next step of, well, how can these people deliver it as a business model? Are we going to let triple LTs become co-principals with lawyers, for example? In the states that have triple LTs, they've revised their rules of professional conduct to allow that, because they know that, well, they're going to want to deliver the services in a smart way, and having triple LTs band together with lawyers could be an interesting business model. So the business side, the delivery model aspect of it follows, I think, from first determining that we're going to allow, as a UPL exception, these non-lawyers to render the services. So I think it comes hand in hand, but I see sort of a first step being, let's decide that we want to let tech do this. And if we want to let tech do this as a UPL exception with the tech add-ons, then we can go to the next discussion, hopefully after lunch, about what might be some business models for these systems, whether they're triple LT humans or they're technology.
Joanne, are you comfortable approaching it that way?
I don't think it matters which order we discuss it. I just think we have to recognize technology is not going to happen unless it's created by the entities that are not necessarily lawyer-owned. So I don't care which order we do it.
Okay. Then the question becomes, how are we going to vote on this? We've got this recommendation. We asked Dan here.
I'm sorry.
That's all right. Whenever you're done. Dan, are you, I see our voting on this in the same way that we voted on the last one, sort of in principle. And I guess the question is, how should we articulate this concept? Are you comfortable, say, voting on recommendation 3 as drafted by the State Bar, incorporating some of the language from the December 2 memo and your separate memo? How do you want to?
Yeah, so I think some of the wording in my recommendation and the following memo behind it, some of it is in there very specifically to address concerns that came up in the public comments that aren't in recommendation 3. So yeah, I'm fine with recommendation 3. I just want to be sure that some of that stuff gets over there, because it is very responsive to certain comments that we received both in the public hearing and the comments.
Yeah. My concern from the town hall meetings and just from talking to my colleagues on the faculty, lawyers and everything, they're not reading the background information. They just read the bold type. And they don't really understand what the bold type is. So I'd be real concerned about just sending out something as the staff has done. We know what's there because we've read what goes with it. But people aren't going to read that. I think you need to bring in some of what Dan has put in about eliminating bias and so forth, eliminating or reasonably mitigating and so forth, and even incorporate some of the titles of the other stuff that he did to flesh out the proposal. I think that's really important, because all I hear from people is, so when are the robots going to take over the legal profession? And I think that's not what we're intending at all. And this is one area where I think we have to be real careful in how we craft the recommendation.
Danger, Will Robertson.
And on that note, so Kevin, what is your recommendation about how we proceed in terms of taking a vote in principle on this concept? We vote on the recommendation as set forth in Dan's memo and sort of combine that with the staff's
recommendation in the December 11 memo?
Well, I had revised Dan's slightly, just, now, if everyone's looking at the December 3rd memo, I'd say technology providers engaging.
For some reason, Kevin, I'm having a really hard time.
Oh, I'm sorry, I turned this on. Okay. I apologize. If you look at the recommendation in Dan's, something along these lines is technology providers engaging in authorized practice of law activities must comply with both the existing law and best practices as implemented by individuals regarding accessibility and usability in recommendations 1 and 2.
Well, I think it's just one.
Oh, okay, yeah. And then technology providers, I would say instead of must work to mitigate or eliminate, I would say must eliminate or reasonably mitigate. I would put the eliminate first because that would be ideally what you would have. And then it wouldn't just be mitigate, I'd say reasonably mitigate. That means an objective standard. Reasonably mitigate bias and other negative effects when deploying algorithmic systems. Such let's see. I'm trying to think of such efforts should include, and then I would list some of the things that you have, like the titles. I don't want to get into them right now because I haven't really fleshed them out.
So could you and me work together on wordsmithing that before the next meeting and then send that to Randy for, we combine that with Randy's stuff?
I think that's a great idea. Are you uncomfortable with our voting that idea, this out in principle today?
Yeah, in principle, I think we should vote that out and then we'll present the specific wording next time.
Can I ask a question? What is meant by comply with both existing law and best practices as implemented by individuals? What's meant by that?
Yeah, I'm just trying to get the idea referring back to recommendation 1. It's really just tying it in with recommendation 1.
So anything that individuals can do, technology should be able to do, is I think the reference he's attempting to make there.
But
individuals are often less accessible than technology. I mean, that might be a low bar, meaning like an individual lawyer, to my knowledge, is not necessarily required to do things in terms of accessibility that an institutional provider is, for example, and maybe that we may impose on technology.
Strike that from that.
Strike that phrase. Yeah.
I don't know if the intention was to maybe talk about ethics by that sentence. That was the question I had.
Yes.
That's the way I read it too.
Dan, did you connect with Professor Gadfield on LinkedIn or Twitter after shooting?
Not specifically, but
okay. She just released a fellow individual professor's paper that the actual elimination of bias is completely impossible. It's self-contradicting. Not trying to bust chops, just setting the standard of eliminate is, or at least making it first, is absolutely utopic.
And it's an active area of research, so I would say to the degree technically possible in whatever final language perhaps, but as far as this recommendation, I think it's okay not to put the absolute.
Right, and I don't want to get into wordsmithing right now. It's just let's not aim for that standard because we definitely won't hit it.
Yeah.
Okay.
Abhijit?
Yes,
I'd
Abhijit.
just like to make one comment. I agree. I think there's agreement that eliminating bias is not possible because it really depends on what you're trying to optimize. But there is a concept in mitigating algorithmic systems, a negative impact of algorithmic systems is the idea of a recourse. If any person has been feels that they've been impacted by an algorithmic decision that is negative, that there is a clear recourse to contest or have that reviewed, so that you're not at the mercy of an AI system. So if that thing, maybe might consider that, the human side of a recourse to an algorithmic system.
Joanna, thank you.
There's a couple of other regulatory concepts for technology that we discussed in our subcommittee. I don't know how the group would feel about them, but we talked about prohibiting sharing and selling of data to third parties as part of the regulatory requirements, and requiring an attorney to sign off or approve the law that's applied to the technology. We decided it wouldn't be necessary to have an attorney in-house, but as long as an attorney signed off that the technology is being applied in accordance with California law.
Mark.
Is this on?
Yeah.
Yep.
So I guess I'm confused. If I look at this memo, it tells me that these are accessibility recommendations, not quality recommendations, right?
Correct.
Okay.
I think quality probably comes up in competence in other areas.
Well, but you do reference in your memo the implementation of the algorithmic system, the effective defects and things of that nature are very important. I don't see it as an accessibility issue. Am I wrong?
I think there are times when it is an accessibility issue, intentional defects. So, whoops, my unsubscribe button didn't work.
Okay, so where I'm going with this is, I'm thinking about Joanne's comment about, are we really talking about the regulation of the entity versus the technology? I'm still quite confused about that. It seems to me, regardless of what the delivery system is, your memo of December the 3rd to me is addressing accessibility issues. And so, and then in recommendation 3, paragraphs 1 through 6 includes that, but includes other things too, beyond that, beyond your memo. So I'm not sure what I'm voting on, but let me just also make a reference here to your paragraph that deals with similar remedies to regular legal practice. I can understand why you'd want to, from an accessibility point of view, I can see that as being very relevant. But if you have a provision like you do in the middle of this paragraph that says that those providers cannot be permitted to include forced arbitration clauses in their contracts. I don't know what forced arbitration clauses means, because I know we have mandatory arbitration clauses.
Yeah.
So that confuses me.
Mandatory might be the right word there, yeah.
Interesting, we can't have those.
It's very different.
And that's an issue. I mean, we have those. The question is, should we not have those? And then we have that the clients have the same remedies when using a technology provided service as they currently do when using human provided legal services. That's going to be very hard. And I'm trying to get my mind around this, it's hard for me to grasp this, but if we're talking about a purely technological delivery of legal advice or legal services, I'm just not sure that the remedies for any violation or any failure is going to be the same as those that apply to a lawyer's breaches of fiduciary duty and professional negligence. Professional negligence is not the same thing as common law negligence. So you're on to something, and I think this is very important, but I don't think it's ready yet.
I would agree it's not ready yet, and probably some of that is that I'm not a lawyer, and again,
Of course.
you know,
But,
don't know
let
some
me
of
just
these
say,
differences.
I thought the value of this would be the accessibility from a technological point of view. You know, which I say your point about, you know, the discrimination issue, I understand that. But what you're trying to say here is that it's got to be available to all consumers, what you're really saying, and it has to be certain standards of accessibility that in your field are applicable. I understand, that's great stuff, and I think we need that. I'm just wondering, when we go beyond that, we're opening a lot of questions. And I think I need your assistance to know that if we're going to have a device that's going to actually produce the result through algorithms, that it has to be standardized and meet all that criteria. That I got. But beyond that, I just don't know enough about this memo to be very comfortable with it in terms of voting on it.
Tony?
Yeah, just to clear up one thing, mandatory arbitration that lawyers have is arbitration that lawyers are required to go to if the client requests it.
No.
Forced arbitration is where the client is required to go to arbitration, like with the banks and like with the telephone companies and all the others that force customers to go to arbitration rather than to court.
You can have forced, forced is not a form I'm used to. You can have mandatory arbitration following the Mandatory Arbitration Act in your fee agreement.
That's
You
true.
have binding arbitration at the end result.
Yeah, I think the forced arbitration that you want to avoid is what you have buried in the contracts in banks and credit card companies and those kind of things that basically say, you know, it doesn't matter what your case is, you can't go to court. And I think that's the issue that's really addressed. And I understand negotiated arbitration provisions in contracts, but we're talking about these, you know, click-on agreements are a different matter.
Yeah, so that's exactly what I was trying to go for. And this actually comes from sort of an embarrassing moment at one of the public forums, where one of the co-panelists brought up that my company's terms of service had limited liability for like up to a maximum of $50, and pointed out that, well, if that was a lawyer providing a legal service, they'd be subject to malpractice claims and professional negligence and all that. Whereas as a tech provider, I can just disclaim liability, and I can do mandatory binding arbitration, and that's not really the kind of world I want to live in. By the way, we're changing that, so don't worry about that. But I think as a matter of public policy, if someone's providing a legal service, they should not be able to get away with things that human lawyers can't. And so that's what I'm shooting for, whether the specific wording...
It didn't come through.
Okay. I do see what you mean is that section is sort of a different animal than the other usability stuff. I put that in there because I see that as kind of a legal dark pattern. It's a way that lawyers have come up with to sort of sneak around what is sort of in an individual's personal interest. And it's not to say that it's not done. Banks do this all the time. You know, pretty much every tech company has mandatory binding arbitration instead of, you know, the ability to have your day in court. So I think we just want to avoid that as a matter of public policy, but the specific wording, I think we need to figure out what. I think we need to have a lawyer come up with that.
So, Mark, I'm not sure that I understand your comment in terms of, do you think that this is not ready for prime time to even vote on it in principle at this point?
I thought the explanations were excellent. I just didn't get this from this document, and therefore I think it ought to be revised. But I mean, it's a good draft, but I'm not sure what I'm voting on at this point.
Jon?
I think one of the challenges here for everybody, even those of us in tech, is the tech that we're talking about applying this to has to already be a violation of UPL in order to be something where we write the exception. And that's like this much of tech. I mean, it's a tiny, tiny amount. Everybody else that's using apps and using their computer, this kind of stuff, that's not the tech that we're talking about. So I think maybe after lunch or something, a couple of us can brainstorm on what that tech really is and what it really looks like and give some examples about it so that we aren't including, you know, the autofill forms, and we aren't including libraries with search indexing, and we aren't including whatever referrals and references that are more library style, which by the way, I love that we had a librarian here, which has been some of the greatest help for me in my legal work that I've had to do. So I think we really need to isolate, because we're down to like the 0.01% of technology that would really be applicable.
Yeah.
So I think there's another recommendation that actually addresses the scope of exactly what you're saying. I don't know that we need to address it in this because it's in another recommendation.
Oh, I only meant that to help everybody understand what we're referring to, because then I think we got to go back to the entity issue.
Randy.
So I think, for me, part of the problem is that the new recommendation 1 is a spectrum. And the nature of the service and the task will be accompanied by an appropriate regulatory requirement, if there is one. If you're doing something that you can do today without any regulation, then we shouldn't be messing around with that area. But I think that will be lost on folks if we just try to say tech should be treated exactly the same way. I almost am now thinking that we need to take tech almost completely separately, because as Johan said, we ought to let the system regulate itself as it pertains to things that are not practice of law activities, because we don't want to stifle that. But if it is crossing the line on practice of law, which is included in our recommendation 1 at some level, and we're going to have appropriate regulation, you know, I don't want to say LLT, but it could be a LLT of some sort, then the tech ought to be regulated too. And so I think the parallelism that I was striving for breaks down, I think, because of that. And so the approach I was aiming for was to try to carve out the practice of law exception part of it from the regulation of the structure and the business side of it by having this perhaps too cute reference back to what we're allowing under recommendation 1. But because recommendation 1 is now more of a spectrum, I don't think it's that easy anymore. I think if you're going to do a tech exception to UPL, we might have to consider it as a standalone, which I think is harder, but I think in the end more marketable because it's self-contained and people know exactly what we're proposing. Right now, if we're tying it back to the first recommendation, the first recommendation is somewhat of a spectrum, more elastic. I think people will have a hard time saying, well, you've told us how you're going to regulate tech, but we still don't know exactly what tech is going to be allowed to do because your recommendation 1 might even allow some court navigator or representation activity by non-lawyers. And we know tech can't go into court. And so I do think now we need to separate it out and maybe treat it as a standalone. And maybe that's what we can send back.
We could have robots go into court. Saying, don't roll it out.
Yeah, danger morons.
Okay, so let me see if I can summarize where I think we are. I think everybody around the table seems to agree that we want to create a tech exception to UPL, and it probably makes sense to do it as a standalone because it doesn't really tie into 1 the way we ultimately voted on 1. Is that a general consensus? So why don't we go back to the drawing board in terms of bringing back to the next meeting what that looks like and have everybody, a number of you, work together on coming up with that language. And I assume
the regulation is gonna have to be built in there too, so we'll be addressing the kinds of things that Joanna was concerned that we don't address in this current form.
The appeal of the original approach, what came out in November, was that whatever was the starting point for the humans would be the starting point for the tech. And whatever was viewed as the next, elevation of that, where it could expand to, that we would also hold that open for the tech as well. And so I feel bad that we're losing that, because I think that was something that would have inspired confidence to our audience that, on the regulatory side, we're not letting tech go any further than we're letting individual non-lawyers go. And as the individual non-lawyer scope of services expands, so would tech. But I don't know how we would do that on a standalone basis. We'll have to talk about it.
Mark?
Yeah. That follows if it's standalone tech, but if tech is being used in conjunction with the provisional legal services, that wouldn't be true. So in other words, tech should not be limited if in fact it's going to be used by those who are authorized to deliver legal services. That is really where tech's going right now. We shouldn't limit that. So if it's a standalone delivery system or one that's operated by non-lawyers, that's a valid point. But if it's, which is happening today, it's being used by those who are authorized to practice law, and it's it's robust and it's growing like crazy, then I don't think you want to limit that.
Kevin?
I want to add that whether we could have a little bit of discussion where we're talking about entity regulation before we leave this area right now. Because let's clarify what we're talking about. Mark mentions that right now, lawyers using technology, it's happening. There's a lot of lawyers who are doing it, particularly I think in big law. But then the concept I think that a lot of us might be thinking about as we look at Dan's memo is the idea of a technology company. Because you guess you don't need a UPL exception if lawyers are using the technology, right?
Right.
So what we're really talking about is the second aspect that Mark brought up, which is technology, standalone technology, and I think the term that's been used before is client-facing technology, which is the interaction is directly with the client and not just used it through the lawyer, which is a lot about what that article that you recommended everybody take a look at is about. That you really don't need it where lawyers are incorporating technology. So I think we need to discuss that, which is what I thought Dan was addressing, Dan's memo.
Okay, Mark and then Terry.
One point of clarification, I assume in that distinction you're drawing, you're have in mind the outsourcing that lawyers and law firms are engaged in today, where they're not just using someone else's technology or maybe their own technology. They are partnering with AOSPs that are wholly owned by non-lawyers, sometimes with lawyers, in using it in the practice of law. That would be the outsourcing side of the equation. That type of technology is robust and it's growing, and I don't think we want to curtail that development of technology. So it's really, what I'm hearing you say, it's the standalone delivery system that doesn't involve outsourcing to law firms or involving the delivery of services to those who are authorized to provide legal services. We have to have that definition pretty much in mind, I think.
So we got Tara and Dan and Randy and Toby.
So Kevin mentioned client-facing tech offered by an attorneys. We don't have UPL problems. But are there other rules that need to be addressed, such as whether a conflict check would need to be run? If I'm administering a tech product, but how do I run a conflict check between both people who might be accessing my platform for the same case? Is there an exception there, or do we need to run a conflict check? Again, this is assuming it's a client-facing product. and not something that I'm using on my end. So maybe I never see the client information. And is there anything, how do we address scope of representation? Maybe it's limited, you're putting in your data, but I'm not reviewing it, even though I'm an attorney and I created this. Or is that something is there confidentiality? Could that be subpoenaed? Maybe it can't because I'm an attorney, but then again, we have the conflict of interest. So I'm kind of wondering how these other rules would play in, again, if I'm an attorney with a client-facing product, but I'm not actually interacting with the client. Does that make sense?
Dan.
So to Tara's point, I think there's sort of backup behind other recommendations that address some of those questions, specifically around confidentiality and conflict checks. If there's essentially what we theorized in our subcommittee was if you use technical methods to blind any human from accessing sensitive information, and can cryptographically prove that, then you can forego the conflict check.
I think that's definitely, because that was all stuff you did in your subcommittee that we haven't done here. So if we're talking about our official recommendations, I think that needs to be brought in, because that's, again, great answer, just not something that we were able to deep dive into.
Maybe we should bring that in, yeah.
Okay, Toby?
Yeah, just a couple of things. In terms of Tara's comment, let me ask you, would you, as having this thing that you don't even look at, oh, sorry, having this product that you may have created, and it's accessed through your website or something, but you don't look at the information, you don't have any, are you responsible for malpractice if it screws up?
I'd like to know.
So, to my
And
mind,
what's my
I think,
level of,
yeah, I think anything that's direct client-facing without an attorney interface, even if an attorney owns it and operates it, ought to be covered by whatever we come up with. The issue is the client accessing the technology directly and getting feedback from the client directly without an attorney's intervention anyway. The other comment I had was with regard to, yes, if the lawyer is using the technology to improve their delivery of services, it's not unauthorized practice. I assume if the legal technician is using the technology, this licensed legal technician, again, it would be the LLT that would be responsible, and therefore it wouldn't be required, it wouldn't be unauthorized practice because the LLT is using a mechanism of the computer rather than their brain to do the work.
so I just had one more follow-up is, what if I'm not having client interfacing 95% of the time, but I'm like TurboTax where it says, stop, your issue is too complicated for my program, and then it comes to me, but now I haven't conflict checked that person and both parties are using my same TurboTax product. How does that get addressed?
I agree, that's an issue.
Okay, it's Randy, and then Andrew, and then Wendy.
Oh, no. No, you just talked about it.
So I was actually going back to Mark and what Johan was saying. Kind of the analytical path that I was going through was to include the tech as part of the section of the agenda under the heading of UPL exception, because I didn't want to be distracted by anything that does not cross the UPL line. And so if a law firm is using tech, as described in the RICO report, it's going on or it's being outsourced, then I think we can talk about that when we get to the third part of the agenda, which is we have a competence rule amendment and we have a 5.7 ancillary non-legal services rule to talk about. And so if lawyers are involved or lawyers are the ones deploying it, then let's talk competence, let's talk ancillary services under 5.7. But when we want to talk about letting tech do something that tech is afraid to do today because it's illegal, it has to be UPL, has to be a practice of law activity. And so, again, the new recommendation one is a spectrum. It could be expanded legal information, non-practice of law, help, or it could be legal advice, determining whether you have a legal problem, the key thing you want to do. And so when we do a separate recommendation on tech now, I say let's clearly restrict it to things that constitute the practice of law, because we don't want to interfere with the other distracting things about how tech is being deployed.
I would like to move to lunch. The reason was I'm finding it hard to stay engaged without my blood sugar kind of.
Yeah. It's a very good point. I think, Wendy, you're passing?
I'm passing, thank you.
Okay, let's break for lunch. Why don't we come back at 1 o'clock? Is that okay with everybody? And get started again?
Unlike 2 hours.
I think what the very first thing we're going to do is wrap up the last piece that we were talking about. And I think one of the things that we need to do is reconfirm who the group, subgroup is that's going to work on this. Dan and Mark, can we enlist you? That was a strong yes.
I heard yes.
And Kevin, okay? And so before we leave this item, is there anything else that anybody wants to say that you want to make sure those folks here that ought to be included in this? I must say, as we broke just before lunch, Neil raised a point that I think was very good, which was we need to continue to sort of craft these to put just enough meat on the bones that we're comfortable making the recommendation without getting down into the weeds that the implementation committee will have an opportunity to do. And so whenever we're tempted to get into way too detailed a recommendation, we need to back off and remember that the details will be provided by another group. Dan?
I just have a question as far as Bagley Keene, if anyone knows. Am I able to have multiple meetings in pairs with people? Is that?
Yeah. So this Brady, can you address the serial meeting concept?
So,
The microphone.
what's the composition of this new group?
3 people.
3 people.
3 people, and it's been created by official action of this body. That therefore is subject to Bagley Keene, that 3-person group.
What if they volunteer?
But could I meet with one person and then meet with another person?
Well, 2 is going to be a majority of the group.
Well, I don't think we're creating them. It's more of a, can we call it a staff assignment to the members?
Yeah, you can do that, as long as they're not voting on anything and they're just going
You
to
know,
approve a work product that then they bring
We're
back.
doing a drafting exercise to return to the full task force in January. But I think the question now is, between now and January, if they wanted to talk to other people or email other people, how do they need to conduct themselves to not get into trouble?
So let's abandon the concept of that 3 being a discrete group that's created. Then there would not be any issues as long as you're not creating a communication with the majority of this group.
Okay.
You guys can talk to each other.
Yeah.
Okay. Like you guys can have a conference call, the 3 of you.
Okay. Does that make sense?
Yes.
We just grant you no authority.
Wonderful. Probably a good idea. All right, thank you.
Anything else that anybody wants to pass on to this group? Hearing none, I think we're ready to move on. The item B2 is recommendations regarding non-lawyer ownership and fee sharing. Professor Moore, we can turn this over to you.
Perhaps. Okay.
To the extent it can be discreetly handled, I think maybe trying to start with fee sharing before the related but separate topic of non-lawyer ownership or alternative business structure. Because I think fee sharing is anchored to illustration rule proposals that were out for comment.
Yeah, what I wanted to focus, sorry. What I'd like to focus on, first off, is the alternative one, proposed revised rule 5.4, that the rules subcommittee put together, and it was circulated for public comment. And we did a number of things. We revised in paragraph A5 and expanded the availability of lawyers, we expanded the ability of lawyers to share legal fees with nonprofit organizations that might have referred the lawyer to represent the client. And this could be either a fee award by a court, which is how the ABA model rule reads, or it could be as settlement of a legal matter. Either way, it could be shared. And then secondly, and this was the big ticket item, which would be a new provision, A6, under which a lawyer or law firm could share legal fees with a non-lawyer if the lawyer or law firm complies with the requirements that we set out in paragraph B. And paragraph B essentially established a ownership provision, ownership by lawyers, and by non-lawyers in a law firm. It says a lawyer shall not practice law in a law firm, which individual non-lawyers in that firm hold a financial interest, unless each of the following requirements is satisfied. We listed a number of requirements. The sole purpose is to provide legal services to clients. Secondly, non-lawyers provide services that assist the lawyer or the law firm in providing legal services to clients. So the non-lawyers who are owners in the firm can't just sit back. They don't just passively invest, but they have to be involved in assisting the lawyer in the provision of legal services. It could be a social worker, say, a family law firm, a therapist. It could be an economist who is helping a personal injury lawyer assess the damages in a particular case, and so forth. We added a provision that the non-lawyers have no power to direct or control the professional judgment of a lawyer. And much of our language was taken from the Ethics 2020, the ABA Ethics 2020 Commission, which finished this work in 2012. They were not the 2020 Commission as in the year 2020, but 2020 trying to look to the future and see how legal technology can be incorporated into the practice of law. Fourth, non-lawyers state in writing that they have read and understood the rules of professional conduct, the State Bar Act, and other laws. Fifth, the lawyer partners in the law firm are responsible for the non-lawyers to the same extent as if the non-lawyers were lawyers under Rule 5.1. In other words, managerial lawyers under our current Rule 5.1 have an obligation to ensure that the conduct of subordinate lawyers comport with the rules of professional conduct in the State Bar Act. And then compliance of all these is set forth in writing. Well, we received, during the public comment period, we received a comment from Professor Stephen Gillers, one of the leading lights in legal ethics in the country. Has been heavily involved in ABA task forces and is closely connected with the ABA and was involved in the drafting of the New York rules, has a well-respected casebook, and has written innumerable articles on the topic of legal ethics. He had a few suggestions for us, and one was to include the concept of law-related services in the rule, that these non-lawyers would also be able to provide law-related services and not just support or assist lawyers in providing legal services. Well, he came to the hearing, the public hearing we had last August, and I questioned him on that because I wanted to know why, if they're providing law-related services or weren't just acting in support, doesn't that make it a multidisciplinary practice type of a firm that we were trying to avoid? And what he explained was, no, this is law-related services related to the provision of legal services. And the example he gave is if you had an accountant on staff or a financial planner, and your personal injury lawyer, and your client has suddenly recovered a judgment, say $1 million plus judgment, would you have someone in your firm, an owner of your firm, be able to provide financial planning services to help that person decide what to do with that money that they have just received in a judgment? That makes sense. It's going to be a lot harder to draft, but that was okay. My point was, originally, before he explained what he was thinking of in that regard, is that we should explore Rule 5.7, which is lawyer ownership, and could be a lawyer, a sole ownership, or a lawyer with non-lawyers in a ancillary business, ancillary to the law firm or whatever entity the lawyer, through which the lawyer is providing legal services. We could address that through Rule 5.7, but I see now what his point was, and we might be able to incorporate it into 5.4. But if the task force were to recommend the adoption of a Rule 5.7, then we could probably just cross-reference 5.7. He also thought that it would be necessary, or he thought it would be a good idea, not necessary, but he strongly encouraged that there be a requirement that the non-lawyers have a continuing legal education requirement as to the duties that lawyers owe. And we had discussed that extensively in the subcommittee of the task force, and we concluded that that was something that we would leave up to the bar, because right now there is no rule of professional conduct that requires continuing legal education, but it's included in the statute for lawyers. But again, we could include a provision or a nod to that effect in the rule. And then finally, his suggestion, and we had also discussed this in the subcommittee and ultimately decided not to include it in the rule. But this is, the more I think about it, the better idea it is to have a moral character evaluation of any non-lawyer who's going to participate in a law firm. Lawyers have to, I should say, applicants to the state bar submit a moral character application, and you have to pass the moral character application. I passed my moral character application long after I passed the bar exam, because strangely enough, I missed the multi-state professional responsibility exam. I thought it wasn't going to be on Saturday, but it turned out it was on Friday. I showed up at the place where it was going to be held, and there it was. The room was empty, kind of like your worst nightmare. So I had to take it in November instead of in August, and so I was admitted in December rather than in November. In admission, okay. They don't have any renewed moral character after reviews. So I think that would be a good idea, and that might be something that we would include in the rule. Now, earlier this morning, when I was talking about the Jackson against Legal Match case, there was the issue I mentioned that the Jackson against Legal Match decision might have a significant and substantial effect on the consent fee sharing provision. I'm not sure it would have an effect on Alt 1. And I think what Randy just said is that we should restrict our discussion to Alt 1 for now. Is that accurate, Randy? Before we go on to Alt 2?
I think you can start there.
Okay. We can mention Alt 2. And the consent is that it simply would require a client's consent to the lawyer's payment of a fee, which would seem and it could be a payment of a fee for clients for a referral of a client. It seems that the Jackson case says that so long as there is any referral, and if you define referral, give it the plain meaning, plain dictionary meaning, then any client referral, any matching of a lawyer, any payment for a matching of a lawyer to a potential client would necessarily implicate the Jackson case, and that you would have to, in those circumstances, the person who is making the referral would have to have been certified under the state bar minimum requirements for lawyer referral services. So there is, I think, a substantial effect. Others in the room might think differently. But as I read the Jackson case, the consent alternative isn't going to work unless there were some kind of a change in the statute. Is that enough of a beginning for the discussion?
So, Kevin, do you have a recommendation? And maybe you answered that already, but we describe some of Professor Giller's recommendations.
Yeah, I think I would, for his second and third recommendations, mandatory CLA and moral character review, I would agree with those and make that part of any ownership, that would be part of the requirements for ownership by a non-lawyer in a law firm. And the definition of law firm within the rules does encompass law corporation and so forth. As for his first recommendation, I'm going to put that off until we get to our discussion of 5.7, because I think it could be more cleanly handled by in the Rule 5.7 rather than addressing it in Rule 5.4.
So is it fair to say that you are moving Alt 1 with those two additional changes, the mandatory CLE and the moral character?
Yes, that's fair.
And is there a second?
Second.
Okay, it's been moved and seconded. Discussion.
Can you scroll it up a little bit, maybe?
Oh, sorry, I don't know where it would go though. I don't actually have the language.
No,
Do I have the language?
The question I would have is, have we decided what kind of entities we want to allow? And based on that, does this alternative fit with what we're thinking conceptually?
I will add
that when we did this, that was the exercise that our subcommittee went through. We haven't done that as a whole committee.
I'm not certain, because I know that, our subcommittee talked about the entities that we thought we should allow, and I'm not sure if this alternative is going to fit with what we were thinking and put forward, that entities could be comprised of
Yeah, I'm not
lawyers,
sure.
non-lawyers, or any combination.
Yeah, I'm not sure we were trying to impinge on your area of inquiry. All we were trying to do is just come up with a relatively modest proposal that would permit non-lawyer ownership of law firms, which would perhaps be attractive to some tech folk who are developing technology-based solutions to the provision of legal services, to become engaged with law firms and work together to develop it in a law firm
But
where...
it doesn't allow them to do it separate from a law firm or separate from lawyers. They have to be associated.
No, I mean, and what we're talking about here is, one thing we would probably have to do with the rule is explain what is meant, and I probably have to draft a comment, by assist the lawyers in the law firm in the provision of legal services. And
See, I
that
don't
would
think
be-
that does anything to access
That
to
would
justice.
be B2 of the rule.
It's for innovation now.
It doesn't do anything. I mean, lawyers can already work with tech companies to help lawyers provide services.
They can do it, but the tech companies can't have any ownership.
I understand, but if the tech company is working with lawyers, there's no issue because there's no regulation even necessary. We're talking about the way to really impact access to justice is to allow the technology companies to interface directly with the consumer. And by limiting entities in this way, we're not opening that up.
So just first, this was like a step to that. So what our committee did was, because we were trying not to, infringe on what your committee was considering, and we didn't know whether that would be approved. So this is like a step towards that, to allow fee sharing with the tech companies.
I think that we need to answer that first question and the way the group wants to go with that first question, whether or not we want to allow entities to be broader than what this rule allows. Because until we've answered that question, I don't know if we're ready to answer this one.
Okay, I don't think that these proposals were intended to be to the exclusion of anything else.
Well, if you're going to revise the rule this way, you are excluding the other stuff. You are excluding technology companies that aren't owned by lawyers or working with lawyers.
But these are the rules of professional conduct that regulate the conduct of lawyers. It doesn't regulate the conduct of an
It actually does regulate how attorneys and how legal services are provided. It creates a business model, and we have to be aware of that.
Randy.
So there's absolutely overlap between the two topics in this section of our agenda, which is the alternative business structure, non-lawyer ownership, and the topic of fee splitting, fee sharing. The thing that I do to keep it separate in my mind is that when we're talking about 5.4, as Kevin said, is a rule of professional conduct, we're talking about what is defined as a law firm, which is, legal department, agencies, legal department, corporations, legal department, a private law firm, a partnership, a law corporation, legal services organization. If you're formed for the purpose of practicing law, then you're a law firm. And right now, only people who are lawyers can have an equity interest in a law firm or a law corporation. The Rule 5.4 would say if that thing is practicing law, so legal services department, it's the legal department of a corporation, it's a law firm, it's a partnership, it's a law corporation, it's an LLP. If you're practicing law, this will now perhaps open the door for collaboration by saying, in addition to the lawyer principles all involved there, now you could add someone who is not a lawyer. But in order to do that, in order to share fees with them, or to be a co-principal with them in that law firm, you have to meet the requirements of this rule. And in addition to what was put out for Alt 1, Kevin has now recommended the addition of two things that we got back in public comment. The non-lawyer would have to undertake a moral character review. The non-lawyer would have to agree to do CLE just like the lawyers do CLE. Now, me personally, I would add back in from the Ethics 2020 the cap on the equity interest that the aggregate non-lawyers could have. I would, 1%, no. Probably more than that, but I think the starting point for our discussion is let's set aside another structure for something that might be 100% non-lawyer owned. It might be multidisciplinary in nature, but it's not presently a law firm as defined in the rules of professional conduct. So,
can a technology company that only provides legal services be defined as a law firm under the rule of professional conduct as you described?
well, right now the law firm is defined as being provided by lawyers. The legal services are provided by lawyers. So there are lawyers in the legal department, there's lawyers in the AG's office, there's lawyers in legal services of LA. Technology company might not have lawyers. So that's how I'm arbitrarily separating it in my mind, just so that we can move sort of in stages through the deliberative process. And I don't know, again, there is definite overlap over what is the policy result of this. Both will get at it, but I'm saying let's start the discussion with the fee splitting that can occur when a law firm is involved, see where that goes, and then we're absolutely going to talk about the next step, which would be, well, maybe we have completely non-lawyer owned structures.
So you don't see this as limiting that option?
I don't think it's being proposed as being with prejudice to the next part of the discussion.
Wendy?
So I just had a question. So I went back and I looked at subsection B. We keep saying non-lawyer owners and principals, but it just says has a financial interest. Why couldn't this be interpreted to allow capping? I have a paralegal who routinely brings me business. I give him 10% of every award that I get. No, but I'm looking at the language of this, and I'm not quite sure why it doesn't.
One of the issues we wanted to put up on the return of this rule from public comment, or the concept of fee sharing for public comment, is do we want to address running and capping? Because fee sharing, one subset of that is when a lawyer offers some sort of compensation for a referral. Kevin mentioned that with regard to the legal match case, but it isn't just online matching services, it is the outright, long-term sort of evil of running and capping. And so the public comment actually came back and said, what you would allow could conceivably allow running and capping. And so one of the things we've teed up is maybe we need to say in the revision of 5.4 that this is not intended to undermine the longstanding prohibitions against running and capping. If that's the finite nature of the financial interest, a compensation for a client referral, then we could conceivably exclude that in how we draft the rule. And so it is one of the issues that I think we have to confront before we finally approve something.
Okay.
If I could just add, it came up after reading the public comment on the rule, which was talking about running and capping. You could interpret E2. It says the non-lawyers provide services that assist the lawyer or law firm in providing legal services. Well, they bring in the clients. That's assisting the lawyer in providing legal services. That's why I suggested we might need to define the word assist, or somehow constrain it, or just say, by assisting, this does not include, or is not intended to permit running or capping.
But why would we do that as opposed to adjusting the language in B and making sure that it's clear that we're talking about non-lawyer owners and not just any random employee of the firm?
It says they hold a financial interest.
Right, what does that mean? Is that what, is that supposed to mean that I have a percentage ownership?
In the fee.
That's what I'm saying. I feel like no matter what we're saying, it just needs to be a little bit more clear exactly, because I know how we're describing it, that's not matching what's up on the board.
It would be a financial interest in the law firm. in the firm itself.
Or ownership interest.
Ownership, because you think about profit sharing that's spread amongst all the employees of a law firm, they all essentially have financial interest.
But that's a carve out right now, so, you know, it's in the bar rules, there's a carve out for that.
Right, but I'm going to the judge's point that we might want to be just more explicit, so we don't have to rely on carve outs as much.
Toby?
I mean, if we're talking about innovation, I mean, one of the things that's really prohibiting, coming from the corporate side of law, the thing that prohibits, you know, innovation coming from our lawyers, you know, the smartest people in the country who are going to the best law firms, is the fact that business people have no say in what goes on, and that, you know, the functionality of what's happening in the law firms, which is why the innovation is either coming because a law firm is setting up a side institution where they can actually bring in technology people as partners so that they can now provide those types of services. And we've got the legal incubators coming out of Allen & Overy and other law firms right now. It's not happening within the structure of the law firm because the business people will not go to the law firms because they can't be compensated.
Right.
Toby?
Yeah, just getting to something Randy said and the earlier discussion about whether the tech company that is allowed to, under an expanded practice of law, to practice law, if you go back and look at Rule 101C, the definition of a law firm, it talks about a professional law partnership, professional law corporation, a lawyer acting as sole proprietorship, an association authorized to practice law. There's nothing about lawyer in that reference, and that, I know what that comes from, but it doesn't say lawyer.
Yeah, I'm construing that under existing law, which under existing law is we don't have any other non-lawyers than the few that are the exceptions.
Right.
Once you cross that bridge and everything we talked about in the morning becomes law, you'd have to go back and change that
definition of law firm.
Further discussion?
Yeah. Let's see. I'm looking at B4. So the issue I see there is it's making very clear that the non-lawyer owner has to follow the rules of professional conduct, right? So does that mean the screening rules that exist for conflicts apply to the non-lawyer owner as well? And if it does, is that an effective tool to deal with any kind of conflict? Because the person is still, when I say the person, I mean the non-lawyer owner, is still contributing financially to what is going on in the firm. So just the question I'm raising.
What do you mean by the person is still contributing financially?
Well, I would assume that if the non-lawyer has an ownership interest in the law firm, that means, so I'm assuming that there's some sort of ongoing financial relationship, right?
Right.
Whether it's stock ownership or something.
Stock ownership, partnership share, and so forth. And what this is saying is that they understand the rules of professional conduct. You want something more in that they are subject to. Does B5 address, B5 says the partners are responsible for these lawyers to the same extent as the non-lawyers. And if they were lawyers under 5.1, they have to conform their conduct to the rules of professional conduct.
Right.
Also the same thing, non-lawyers in the law firm also have to conform themselves to the rules of professional conduct. Your concern might be with Rule 1.10, the screening rule.
Right.
Which says that non-lawyers might be treated differently than lawyers. And I think that there might have to be a change then. If we want to subject them to the same screening rules as lawyers, if they're owners, they should be subject to the same screening rules. Then you might have to have cross-referencing comments in this rule and in Rule 1.1.
I am curious how you would apply this rule in a situation where a law firm decides to go public. And there are multiple shareholders, none of which have really any involvement in the actual running of the business.
And that would have to be an entirely different rule. I mean, at that point, we would, perhaps if you do have public ownership, in other words, passive ownership of a law firm, then I think you're going to have to go in and completely revise this rule.
So if we suggest adopting it as is, we are precluding that option.
Well, I think, to go back what Randy said this morning, we're not talking about maybe adopting every recommendation that we have.
I understand, I just want to understand.
And at the same time, it's not going to all be done all at once. That probably is not going to happen. But Randy gave the example of the multi-jurisdictional practice, which granted the possibility of foreign lawyers practicing here never came to fruition. But the point is, you work at something, you show this is working, now we can take the next step, and we can go to passive investment. And that would require, I think, an overhaul of the rule. But to say that recommending the adoption of this rule precludes the other thing, I don't think any of these rules were intended to be preemptive of any other, or any recommendation is intended to be preemptive of any other recommendation.
Well, it would be good if we're consistent in our recommendations. So if we decide that that should be allowed, it's really not consistent that we say this is the rule we recommend.
I think we could exclude public, investment from this rule, because I don't think we want public investment in law firms, do we?
Well, it's worked successfully in other countries, and so I'm not sure, and it's helpful for law firms to get the funding they need to really upgrade their technology and so forth. So there is a reason to allow it, and there hasn't been any problems associated with that that's come out of it. So I think we should be consistent. We need to figure out if we want to allow that and make sure that whatever we're recommending doesn't contradict that.
Alan?
I just want to add to what Joanna has already said. I think, let's imagine a world where a law firm creates a cool technology and now they have to, sell it, right? They have to make it available. The way traditional business does that is by raising capital, right? So I think really this is really tying the law firm's hands, and the discussion has really become about tech companies would come in and do this. Tech companies are already doing this. Deloitte, all those companies are already doing it. Atrium Law here in San Francisco, right? They've set up a very well-funded separate business entity. The law firm just feeds the money over. They buy the license, they license the technology from the separate company, and the law firm is really just a portal to get that money under the current regulation and pass it over to them, right? That's kind of the reality. So I want to remind people, I think the rule this discussion has really become the tech companies are the bad people here, but it's really the tool to benefit the law firms at the end of the day. So I don't think we want to limit publicly traded or whatever, you have to raise capital to kind of.
What about going back to the percentage? The limited percentage ownership?
I'm not sure I followed what you.
Previously, under there was you can only have, I forgot what the one under the ABA was, for the one model we took it from. Was it 40% ownership or 25 or something?
No, it's 25, I think.
Okay, I've got Neil and Kevin and Mark.
Okay, so it was mentioned that public ownership has happened in other jurisdictions, like Joanne, you mentioned that, and that there's not been any problems. But the question I want to ask is, at least in those jurisdictions, what evidence exists that existence of the ability to go public generates innovation, generates the kind of change that I think this group is ultimately trying to achieve? So I'm just asking that question.
It's a question that came up a lot in public comment. And
yeah, I was going to ask a similar question. And the thing is, if you look at the Slater law, I think it's Slater and Gordon in Australia, they're a personal injury law firm. It's not like clients who have a good case can't find lawyers. I mean, they're going to get lawyers because the lawyer's going to take a piece of the action. And that's what the passive investors are interested in, getting a piece of the action of the particular case, which is where they're going to bring the money and recover a judgment for their client. That would be true here, but what effect is that passive investment going to have on actually increasing access to justice here? And I've heard that, yes, in those other countries that implemented the passive investment rules, that access to justice wasn't the goal. Well, so what? But has there been a side effect, nevertheless, that there has been an increase in access to justice? And to me, what firms are these folks going to invest in? Are they going to be investing in the smaller law firms, or are they going to be investing in big law? Because that seems to be the ones who are making the most advances. That from what I've been reading, the ones who are making the most advances in technology and innovation are the big law firms, to make themselves more efficient and to more efficient delivery of legal services, and it increases their bottom line essentially. So I think that passive investment, we're not excluding the concept, but if there's something that might move us along, attract innovation in the law firm, and the question is, again, will this 5.4, this modest proposal, even have that effect of increasing innovation?
I can respond to that. I think that everything we're proposing, we don't know yet if it's going to increase innovation and increase access to justice. We just know that what we've been doing isn't working and it's getting worse. And if we look at it on the other hand, is there a public protection issue doing it this way? I'd say the evidence is it's not hurting the public. So because there isn't a public protection problem associated with it, we should look at it and give it time to see if it actually does. If it's improving the efficiency of a law firm, it should, you would think, maybe drive down the cost to the clients, whether they are corporate clients or individuals. But I think that looking at whether or not it actually creates more access to justice is looking at it from the wrong side, because it's just, we just don't know unless we try.
Mark.
This continues to be a very unfocused discussion that deals far beyond access to justice. I said before, and I'll say it again, if someone came up with a proposal for a specific service in the areas of critical need that we've identified in the access to justice reports that would be benefited by a combination of lawyer and non-lawyers in a certain setting, maybe a sandbox or some other approach, you might have something to discuss. But when you have this broad-ranging discussion of having 5.4 materially altered in all areas of practice, in all forms of specialties for corporate law, and try to justify that let's take a chance and see how it's going to work, it's not responsible. So unless it's focused on some specific detailed project or proposal that someone's proposing to narrow the justice gap, it doesn't make any sense. And I think that's why it died in the ABA. That ABA provision never got off the ground. There was no support for it. There can be support for changes to 5.4. We already made some changes. And I'll end with the fact that the Supreme Court articulated extremely well in the Fry versus Tenderloin Housing Clinic case the reason for not allowing corporations to practice law. And they did it in the context of the distinction between nonprofits like the Tenderloin Housing Clinic that is allowed to practice law, which has lawyers and non-lawyers sharing fees, and the for-profit entities. And that's a 2006 case. I have yet to see anyone raise an argument yet in this room or elsewhere that says that logic and that rationale isn't valid. There may be opportunities for us to create certain inroads into profit sharing for lawyers and non-lawyers on a context by context basis. That would make sense to me. But to simply change the rule for all purposes, for all law firms everywhere, without considering the consequences is not what we are about.
And Mark, I take it your comments go not just to the broader things we're talking about, but also to the 5.4 that.
I have so many questions about their proposal. I would bore the heck dickens out of you to raise them. I think there's a lot of issues here. And we're not in the rule drafting stage. I don't even know why we're doing this, but we're not in a rule drafting mode here. I do think you should take up 5.7. I think that would be a good idea. But you're drafting exceptions to 5.4. We're not talking about how that affects the remainder of 5.4, 5.4C, 5.4D. There's just a lot of issues here. And I can tell you, as being in the rule drafting business for many years, these are very complicated issues. The complexities and the unintended consequences of what you're proposing are mind-boggling. And I don't think we're in a position to do that in this room.
Jared, did you have your hand up?
No.
Leah and then Bridget.
I just had a question. Is the group continuing to consider the idea of the sandbox? Because the sandbox is a bit of an easy way out, and you don't need to deal with any rule changes. You essentially say, if you're approved to be in the sandbox, then we aren't going to apply these rules to you. Essentially get a waiver. And so if you can test out various innovative models, I don't think anybody's going to go public in a sandbox, but you could certainly test out different models of non-lawyer ownership. And you could certainly test and collect the necessary data to evaluate the impact on increased access. So I'm just wondering if the group is set aside the concept of a sandbox, because in a way it does allow you to move past wholesale rule changes at this time.
Bridget.
That's what I was going to say actually, is I feel like having this discussion about what's in the rule is like a chicken and the egg problem a little bit. It's hard, I think kind of to Mark's point too, and Joanna's earlier, we have big concepts that we haven't fully resolved how we want to handle it, and it's hard. And I understand we were operating in a vacuum really, but even that was frustrating at the time because we were having different conversations than you, and then you draft a rule that even though you're not meaning for it to be exclusive of what we're talking about, at this point, I think it's really hard to be wordsmithing an ethics rule, whether you can arbitrarily make it different or not. I mean, I'd rather have the conversation. I think you're right, Mark. I mean, the public comment is right to be worried about unintended consequences. And I think that is the purpose of the sandbox in a way that we could be measuring some things and figure out some, what might happen in a smaller controlled environment in a way that we can test some of these things before we were just wholesale do it.
We've got Tara and then Mark.
I don't want to speak for Joyce, but one of the things going through my mind when we were crafting our proposal, it wasn't a sandbox so much as an open door with articulating what we wanted focused, and I think it would fit in with the sandbox proposal. I also wouldn't want to get into the nitty-gritty of what a sandbox proposal would mean, right? I like the idea of focusing, and I probably would have had a different answer before today's conversation, because I think it was worth taking a look at 5.4 and then kind of looking at how we're all perceiving it and being like, actually, maybe that's not what we should be doing. Let's set it aside. And going back to kind of what we were doing this morning. I do think, however, that there's other rules that we should do this again and look at and say, well, can we make a change for this rule, like the advertising rule? Because some of those can be implemented separate from this larger sandbox implementation. So I think this was a really positive exercise that has changed how I'm looking at it, and now I'm looking more towards the sandbox. and saying these are the tasks and these are the areas we really want to focus that on. But I don't think we should just skip this exercise for the future, for other roles, because I think it's been valuable.
Mark and then Randy.
Yeah, and that's how I read the Utah report. Which I think it took a better approach to this. I'm not sure what sandbox approach, they outlined it very nicely. They give you a very nice definition, how it's going to work and how it's going to be set up. But unless you have a specific context, a specific application of this exception to 5.4 in a setting where you know what the parameters are, you know what the services are. You look at the areas of critical need, they range from fairly basic services to extremely complex areas of law. And if you have, I said this before at one of our earlier meetings, if I were in charge, someone came to me and said, we have this amazing technology and proposal that we believe will really aid consumers to understand their legal problem, but we cannot get off the ground. We cannot possibly implement this because we can't get the investment. We won't do it unless there's profit for those folks in this area. I would listen to that, but I would never listen to it outside a specific context. And I think that's what Utah, I think, is trying to say. And I think that's what we should do. You're not foreclosing the opportunity to have innovation at all. You're simply saying you got to put it inside some contextual application that you understand what the parameters are. You understand who's going to be the investors, what the service is going to be, who's going to regulate it, and that sort of thing. Then you can get your arms around, can this be done without a combination of lawyers or non-lawyers, or is that an essential or useful ingredient? That's what I think the approach ought to be.
Okay, so in the PowerPoint from the last meeting, one of the observations was, actually we can switch back to that, was you could do right there, the narrowest of things in the short term, far right top corner, amend 5.4 only phases, and the only thing you would want to do now as a deliverable is say, we want to amend A5 to have the expanded language with regard to sharing a fee with a nonprofit organization, so expanding it beyond the fee awarded by a tribunal. So you could do that now, and you could reserve the controversial changes for a different implementation methodology. And so I said, well, maybe you get a rule of professional conduct with a sunset or something creative. But if you go back to the other screen, in the November materials, we identified the key commenters that the drafting teams and staff put up there. And you do actually see that when it comes to the idea of a more controlled implementation, we had folks who said, we support this if it was a sandbox or a pilot program. And the Association of Disciplined Defense Counsel, the Los Angeles County Bar Association, scroll down, I just want to see who the others are. Crispin Passmore, the UK expert, would support our fee sharing proposal if it were a sandbox. And the consumer attorneys would support if it's a sandbox but it was confined to nonprofit. And so just identifying the options here, I don't think we shy away completely from Alt 1 of 5.4 because we put out a change to the sharing of fees with nonprofits that I think no one objected to. No one said we shouldn't eliminate the restriction on court-awarded fees because we think there's good that could come of it.
Or settlement.
Or settlement, because what was it? Oh, it was the incubator. Dan Rice, who had been pitching incubator to us and said that his nonprofit incubator could profit from a broader expansion of the fee sharing restriction. So you could have a recommendation to the board that says, we think we have one change to a rule that might advance the cause that we're not too worried about, but we have other changes that we're a bit more skittish about and would only feel comfortable endorsing to you if there were a lot of protections, whether it's sandbox, pilot program, or something else, but at least we articulate with some description. We're not drafting rules, but we're saying for the benefit of the implementation body that you don't have to start from scratch with where you think the parameters of this might be. We think that there's a conceptual consensus on maybe not passive investment, maybe yes passive investment, maybe a cap on non-lawyer ownership, maybe not a cap on non-lawyer ownership, but having some discussion of these key considerations that go into what could happen in a sandbox, I think would be very valuable to the implementation committee. Otherwise, you're just handing it off to them and saying, we did one thing, and now you go figure out the rest, which, you know, we know a lot, we have a lot that I think we can say about it, and it wouldn't be binding on them. They could still explore a different end result, but at least we gave them the benefit of our thinking that even if it's a split vote, 50% would test non-lawyer passive investment in the sandbox, 50% would not. But at least we have some record of our thinking on it when it's handed over to the implementation body. But I do think the idea of there could be something we deliver now that we could implement in the short term and also describe what could be done on a more careful basis.
Toby.
I have a question for the entrepreneurs in the group, the non-lawyer group here, and that is how many would in fact be willing to put in the investment to create an entity in a sandbox, knowing that within 2 years somebody's going to look at it and say, no, it isn't working, forget it. And I've heard a lot of people that I've talked to that say, no, you need some certainty, some ability to know that you're going to be able to continue doing it.
I think and I can't speak for all entrepreneurs, although sometimes I wish I could.
We do.
What I would say is, instead of saying it's going to be taken away in 2 years, I think if you worked out to say, so long as X, Y, or Z do not occur, or Z, depending on where you are, then it's fine. It's a different thing. So I'm being very clear as to what the tripwires would be. And then it could actually happen in perpetuity. So the first group that would be allowed to do it would, in a sense, be allowed to continue along that path in perpetuity, so long as they don't X, Y, or Z, meaning, you don't get X amount of complaints, or the way that I would frame it is we would want to see what the overall performance of lawyer delivered services, what their level of kind of complaints are, et cetera, and then benchmark it to that. Because what I would also worry about is if we say it has to be a perfect kind of rollout, we don't expect that from attorneys within California, so it would be unfair to do that for those tech companies.
I guess where I'm concerned is I would want to see results that say, yes, it increases access to justice. And if it's just, well, it's not hurting, that's not enough for me. I want to see something that says, yes, in fact, it's making things better.
I think, and this might be a problem that we're going to face as a collective group as well as a collective movement. I think the idea of what is access to justice is a big question. For me, access to justice is delivering legal services any way, shape, or form, and to any income level. And in that case, if someone is happy with the outcome of what has occurred via that legal technology outfit, and it ended up being the exact same service that they could have got from a lawyer at a cheaper price or at the same price, that to me is access to justice. Access to justice is improving and opening up the ability and options that individuals have to access legal services. That's it. So the idea that we're going to say, you have to show me you've improved access to justice, I would say, did they deliver legal services? Yes. In the delivery of those legal services, did these tripwires get hit? No. That's access to justice.
So Joyce and then Simon.
And I just wanted to respond to Toby's, did it increase access to justice? And I would point to, and I'm trying to find it in here because I read the ABA's
Innovation.
Yeah, it's in here, it's in the materials, and what it did, the report to House delegates where it says we strongly encourage everybody to do this, what California, Arizona, Utah, and everybody's doing. And they looked at the UK experiment and said that within I think it was like a 6-year period, the newly authorized or entities were able to access a significant amount of market share in an environment where the existing law firms were not showing a decrease in market share. So I think at a very basic level, if you want to get away from the access to justice, because I know, I have an idea about what that is, and everybody, I think, kind of, again, we could probably get 50 different answers, right? But I think just saying that it's supply and demand. If we've increased supply by making these new entities available, and we presume that the market is a finite thing, then we would have had to have increased access. I mean, it's not a perfect way, but it is a way to think about how you might measure that simply, cleanly, easily, and defensively, as opposed to coming up with, a definition of access to justice that we then all have to agree on, and then that's a whole nother.
I agree with you completely, Joyce. I think one thing that also we have to understand and almost accept the reality of is if we are able to offer a way for folks to do something, even if it's a quicker route or what they think, or the consumer ends up saying, you know what, I just enjoy this way of doing it a lot better than speaking to a lawyer. And maybe I even paid more, but I would pay more for that, or whatever that may be. We have to really kind of change the way that we frame this, because if we're saying access to justice means X, Y, or Z, it's a very slippery word. We don't know what it's defined as, and I think, like as you mentioned, Joyce, everyone has a different definition of it. But what we can be sure of is that if we increase the optionality that individuals have and people engage with those services, and then we track the feedback they have about that service, including even as something as simple as what were the complaints. We don't even have to have them raving about it. We would just have to even track complaints about it. I think that's access to justice. That I don't see why it wouldn't be.
Simon.
Thank you. And I really believe that if we don't address Rule 5.4, then we failed as a task force. And so, and I admire Mark. And I like Mark so much that maybe we should propose to have like a whole meeting dedicated so he can ask all of his boring questions, so we can try to get it out of him and convince him that that 5.4 isn't as bad as he says. I do though agree with Mark that, and I trust his judgment and obviously his decades of experience in writing rules, that this is a tough problem, and we can't do it all in one setting. I also don't believe that that should discourage us. If it was easy, it would have already been done. And so to me, I also think that there's this mind shift going on in terms of when we look at Rule 5.4 and those, as Andrew was saying, when there's different kinds of tools and mechanisms to how we deliver access to justice, in this 21st century and with technology, lawyers realize that they are now not the only ones that have this vast toolbox to help people in need and help the millions of people. When a lawyer is paired with a really smart engineer wizard to create really great technology, that is going to change the world. And it's already happening, and it's gonna change the world whether or not we rule on 5.4, because other states are going to do it, other bar associations are gonna do it. I think to me, it's whether or not we wanna be the responsible player and be the leader in this, and we wanna set the tone for it. So rather than yes or no, are we going to talk about it? We are going to talk about it, because I'm not coming to these meetings anymore if we're not going to figure this out and be the real leader in it. So I really want to try to get Mark on board, and he may vote no on everything through and through, but at least Mark is we're able to have a serious conversation around it, and we learn from him, and then we try to make it good. I just think this is so fundamental to why we're here.
Okay.
So I appreciate the different perspectives on access to justice issues, and I thought that was very well stated from both Joyce and Andrew. But in the course of these meetings, I've been hearing different things. I've been hearing that angle on the take of access to justice. I've been hearing, oh, the legal system is in crisis, we need to do something. Right? But the bottom line is, when it comes to the court's not going to look at and make a decision on something when someone says, trust me on this. That's not how the court makes decisions.
No one's asking for that.
Yeah, well, I hope, right?
No.
But, you know, at the same time, the court makes decisions based on evidence, and also with the foresight of seeing how things will actually play out. How a rule, if this is the rule, what will happen in the real world. So I'm just raising that issue. Now, putting aside the sandbox, putting aside the change to 5.4 about nonprofits, you still got to pass that hurdle, and that's convincing the court that this is a good idea. When I say this, I mean the various changes to Rule 5.4 that are at least on paper right now in front of us.
Yeah.
So to try and move this along, I think there were two, I can't remember what exactly they were, that Randy mentioned, two provisions in 5.4 that maybe aren't so controversial, that maybe we could address and see if we can get votes on those. I mean, again, we're just recommending some language. I know one of them was the one I was really into, which is that they could share fees even if they weren't court ordered. And I can articulate the reason for that for the court, which, you know, would be that, because why should we have to go to court? Why can't we just settle it out of court and avoid all that cost? And then why, therefore, should fees still be shared if we came to it the same way? And if there's a dispute over that, you can always go and mediate or arbitrate that particular dispute. But I don't think you should require the involvement of the court, because that's not always the best way to resolve things. And I can't remember the second one, Randy. I think it had to do with nonprofits. And then the second issue, separate from that, I think that we should make sure that we articulate all the sandbox parameters if we're going to throw that out there. I don't know whether we're going to suggest that there's a sandbox or not, but it sounds like we at least might say, hey, maybe you should do a sandbox, but if you do this, you should consider these things, because I don't think the implementation committee will have the same makeup. I guess it's safe to assume it won't. And so we need to make sure that we capture, like Randy was saying, capture your thoughts and ideas on what would make you innovate. And that way the court can see, well, these things are definitely going to prohibit innovation if you have a 2-year cutoff. But if you have this and there's no harm done, well, now you're going to really motivate people to innovate really fast to get into that sandbox window.
So, Lee.
I was just going to go back to this question of what is increasing access. I do think we have a couple of places we can look, some of which would allow you to do a quantitative assessment of that, which is, I think, really helpful, sort of objective rather than subjective. So you have the Justice Gap study that's going to come out and tell you that 55% of Californians had one unmet civil legal need in the last year, regardless of income. It's higher for those under, the 125% of poverty, slightly lower for those under, but at 55% all Californians. So a very easy statewide goal could be that you see that percentage coming down over time, right? You should more access, fewer unmet civil legal needs. If we did have baseline data, similar baseline data on unrepresented litigants in courts, we don't have actually current statewide data, all 58 counties, but that's not impossible to get. That's another measure. Decreased incidence of self-represented litigants. That's a potential measure. So I think those are two very easy access measures. In addition to yours, Joseph, I think is interesting because it's really an economic one. It's looking at legal spend. And we saw from Professor Henderson that over time legal spend is ballooning in the corporate legal side, shrinking in the people law market. So another measure would be, we don't care what's happening on the corporate legal side, but are you seeing the people law market increasing? So I think those are very clear quantitative ways that you could measure the efficacy. It would be hard, it's hard in a sandbox because 5 to 10 initiatives are not gonna move the needle on legal spend in California. But I think it does begin to allow you to articulate, this is why we're doing it, and every 5 years we're gonna redo the Justice Gap study, for example, and see where we are. So just gonna throw that out there.
Bridget.
Just a comment on Tara's and Randy's point. I don't object to approving little non-controversial things, but what concerns me is that it's just really tinkering around the edges of this rule, and I don't want it to come out as like, here's what we've done, after all of this discussion, here's what we've come up with, we can share fees with nonprofits. I mean, it just seems so. So I just want to say, I don't oppose that, but if we were to approve some of those things, I would almost have it be like, at the end, and be like, by the way, here's some things we talked about that we agree can be implemented relatively easily, but I personally would not want that to be like the focus of our recommendations.
Johan.
To go back to Toby's question real quick, no, I woun't spend a dime in a sandbox, okay? But neither would most other tech people. And we can prove this in today's market because we have plenty of legal platforms that are out there all around the country. So what actually happens is I'd say, okay, New York's not gonna put me in a sandbox. I'm gonna operate there and in 30 other jurisdictions. If California says it wants a sandbox, then I may make it available in California for that time, but it's not gonna have the investment behind it, right? So that's not even an issue. We know alternative 2 is still hanging out there. And alternative 1 here, it doesn't, Joanna hit it. It doesn't do anything to the justice gap. It actually secures and inhibits any sort of innovation to any degree whatsoever. Not-for-profits, which can already be done, whether it's judgments or settlements or whatever, it really doesn't matter. 5.4 is the heart. That is the heart of this entire thing. If we don't not only approach it, but bring about significant change to 5.4, nothing else matters, okay? And don't get me wrong, I think this genie's out of the bottle anyway. So you're gonna start seeing solutions in other jurisdictions that are gonna overflow into California regardless. And what you're gonna find is they may not take the structure of a quote-unquote law firm, but they'll definitely be busting UPL on a regular basis. And what I think we're doing is we're presuming lawyers to be in charge. We're presuming that the court is going to be the finder of the fact in this issue. And on the issue of trust me, I don't think anybody's saying trust me, but what I do know for a fact from the technology perspective is we've made these kind of fundamental changes in every single other market segment in this country, in the world. Okay, we brought technology into banks. You want to enter your bank account, you go to the same website everybody else goes into for that bank, but you get to see your financial information. That's something that we have a very hard time on here. If you want financial advice, if you want medical advice, we have made these accommodations because the market demanded it. And we have stopped talking about the client's ability to make choices, the client's need to be insured to access to justice, not maybe access, but absolutely insured. So I know we don't want to dive into alternative 2 for whatever reason, that's fine. Alternative 1 is just not cutting the mustard. Thank you.
Heather.
I'm looking at a chart that Bill Henderson posted in last couple weeks. I know I shared it with some people, showing that the number of lawyers going into private practice is shrinking, and especially in that 1 to 10. And if we're thinking about who's providing access to the people with fewer means, it's that 1 to 10, and we're seeing fewer and fewer lawyers going into that. By allowing to have co-ownership of a law firm with a quote-unquote non-lawyer, it allows people to start creating law firms or creating opportunities to bring lawyers into a company where they can provide those means. One thing I found out in the last few weeks is the fact that Washington, D.C., the country's capital, you can have non-lawyers own law firms, which is why all of the big 4 are opening their corporate headquarters in Washington, D.C., because they can have non-lawyer ownership there, and that's how they're circumventing a lot of these laws. The largest law firm in the country, in the world right now, is Deloitte. That's where the majority of law firm is, legal experience is going, and that's where people are headed. They're headed into those companies. So I think that a lot of the fears that we might be, hesitant about, they've already been going on and happening without the sky falling. I mean, if you look at Washington DC and lawyers, but what we're missing is the fact that we don't have people providing legal services to individuals. So corporate law is doing fine, but individual services are not being provided. We can find technological solutions, but we're not going to see an increase in representation in court because lawyers they're not going to do that because the litigants aren't going to be able to afford, the cost of a lawyer. They're not going to be able to afford $100 an hour, let alone right now, the cheapest I'm seeing is $350, $400 an hour. And that's for a solo practitioner, to go into court. No one can afford that, no individual. It's very expensive. So, when we're talking about these things and we're looking at the fear, I know where the fear is coming from, and I know where, a lot of the comments are coming from. But 5.4 is the root of all of this, and if we're going to provide more services and we want to get people in front of lawyers, yes, we can do that with technology, but at some point they're still going to have to come face to face with a lawyer, and we're going to see fewer and fewer of them, representing people on the lower economic scale.
Dan.
So I'm no fan of 5.4, but separate from that specific issue, what if we explore other options for maintaining professional independence that other industries have used beyond just limiting ownership? Is anyone open to that?
Such a
example. So like financial advisors, accountants, plenty of other industries, medicine. They have plenty of other professional independence mechanisms that go well beyond ownership of essentially the fees that they're collecting for their services. Is anyone open to exploring that? If we get rid of 5.4, are there other mechanisms to put into place to mitigate the concerns that that independence will be compromised? Maybe some that are more compatible with entity practice.
I'm not confident it's under threat.
Yeah, I think it's a false assumption that lawyers will be somehow corrupted by partners with law firms. And just like we're talking about evidence, you can go to activistlegal.com. It's actually somebody that I know. He's a partner there. He's a community activist who got fed up with the access to justice system, started a firm in Washington, D.C. specifically to help people with eviction, housing litigation, housing loss mitigation, things of that nature. So there is evidence, I would say, that suggests that fee splitting could also have these positive outcomes, not just negative ones.
I think I know the answer to this, but do we have any evidence that the current Rule 5.4 has a positive effect on professional independence?
No.
I mean, the recurring theme here is that to make any proposed changes to the rules of professional conduct, we need hard evidence to back up that it's going to have an effect on access to justice. But when most of these RPCs were passed, where was the hard evidence that says, we need this RPC because of X, Y, Z? So where's the evidence that 5.4 in its current form maintains the professional independence of a lawyer or contributes to it because of that ownership requirement? And I don't see that. So there isn't any particular reason to, to keep it around just because of that basis. I just think maybe we need to question the status quo because there's no basis for it.
So, Kevin,
I think it's important, Neil, you might know the most about that. Do you have any studies that show that 5.4 has been effective? Just to respond to Andrew, just because I don't know enough about the space.
Well, I just point to the discipline system. when attorneys do cross those lines, and presumably those were the result of client complaints because clients felt like the attorney was compromised. So I think the answer is just that simple.
If I could address that, curiously, the title of the rule in the model rules that in most jurisdictions is independence of professional judgment. That's what Rule 5.4 is called. I think that if you look at the the loan modification issues that arose in the late 2000s and early part of this decade, you'll see, in fact, I had several of my former students got caught up in it. They were essentially went into business with non-lawyers who told them, don't worry, this is perfectly legal what we're doing, there's no problem. And they all were disciplined by the state bar for having done that. They were told, this is what you need to do. And they started to follow what they were doing. They joined in this because only lawyers were allowed to collect advance fees. My students saw the fees disappear. The non-lawyer pocketed them. And after having told them that, no, you don't have to do this, you limit what the services you actually provide. You get a flat fee. So, yeah, there are concerns. There are concerns, and it scares the heck out of me with my students. I think somebody made I think it might have been Toby earlier, that having been in law school, to send people out to practice after a year in law school is kind of a scary proposition. They don't learn how to practice. You might be permitted to practice, but it doesn't mean you know how to practice. Once you are permitted to practice, you pass the bar exam, you're sworn in, you pass your moral character application, and then you go out there, you don't know much of anything. The first year of practice is the scariest year. That's where you really start to learn how to go about representing clients. And when I have a lot of my former students, they start out as solo practitioners because they're not getting hired by law firms. And when they're doing that and they're trying to find an income, I think the term is income stream from someplace, they're willing to enter into various and sundry things. And if you're going to be employed by, say, an Amazon or a Walmart, we'll forget about Sears these days, but if you're going to be employed by one of them and you're going to be given strict guidelines on how you go about practicing law, that might not be in the best interest of your clients. So the concept of just throwing it out, and you tell me, does this rule actually contribute at all to the independence of professional judgment? I would have to say it probably does. It probably does. That doesn't mean that you can't go in and make some changes that will still ensure that there's going to be that independence of professional judgment. But to wholesale just throw it out, I think that would be a bad idea.
Mark and then Toby.
In my sense, I understand the frustration, and I think it's important to clear the air a little bit here. There's nobody in this room that wants to stifle innovation. I have been involved in this area for so long and attended so many conferences with Mr. Susskind and others around the world that talked about the changes in law practice that are beyond debate. Technology is coming. It's going to have a tremendous and revolutionary impact on how legal services are delivered. There's just no question about that. We're not here to debate that. At the same time, I think it's a misnomer if those of you think that 5.4 is a protective rule that is trying to protect the monopoly for lawyers. The Supreme Court would never do that. What's really at stake here, when you talk about access to justice, by the way, it's not hard to define access to justice. Just look at the access to justice reports. We're not talking about corporate law. We're talking about those unmet needs by people law. Professor Henderson made that clear. Professor Sandiford made that clear. That's what we're talking about. But the access to justice has two pieces to it. We've talked about the access part. We haven't talked about the justice part. And that's what drives my reservations. Not that lawyers are not going to get into arrangements with non-lawyers. They're doing it right now with ALSPs. They're very robust and far-reaching and dynamic and they're here and have a tremendous impact whether you get rid of 5.4 or not. It's going to happen. So 5.4 is not this huge rock in the road. I mean, sure, you can change it, but it's not, innovation will take place regardless of that. The point is that you have a system of justice in this country that relies and is dependent on that one-to-one relationship in areas of highly critical need. And you don't throw that out with the bathwater. I mean, everybody deserves their own lawyer. What you're trying to do is create a system that allows for one-to-many. Well, fine, and we need to do that. But that, you don't, 5.4, as Kim was saying, it preserves independent judgment. It does a second thing. It preserves the attorney-client relationship. That is a very important concept in a system of justice. Not just in criminal law, but in all forms of civil law. Just think about civil commitments. Think about conservatorships. Think about parental rights and about things like that. People deserve to maintain that type of confidential relationship. It may not serve access to justice completely, that's true. And you may need to have other forms of delivery systems that will give more services to the many without disrupting the attorney-client relationship where it is desirable and where it's needed. That's what we're talking about. And we can do it. And we can do it responsibly. But that's why my reservations, I'm not trying to say anymore, I'm just saying that the reservations really have to do with the quality and the respect and the confidence, the integrity of the judicial process in this country. It's a jurisprudential issue. And 5.4 is intended to serve that purpose. Maybe it's gone too far, and maybe it needs to change. And I'm the first one to say yes. But to say that it's there to serve as a barrier to protect the lawyers' monopoly is really not accurate.
Okay, so it's Toby and then Andrew.
I wanted to respond to Dan's comment about how all the other industries have managed to find a way. I don't know about anybody else, but I find it not preserving independence when I go to my doctor and we agree on a treatment plan. And the doctor then has to clear that with the corporate ownership, who then has to clear it with the stockholder-owned insurance company, and unfortunately, in some senses, maybe even with the government, before I can get the services that the doctor and I agree are what's needed. And it's not just the money. It's not just a situation, well, I can pay more for it. No, I can't get that service from the doctor. So I'm not sure the medical example is the best one to use in that situation. I agree with Mark.
Here's the thing about the medical example you just provided, though. I mean, if you look at how many Americans have access to even limited medical attention versus limited legal attention, the results are the delta is huge. And the system that is in place from a medical standpoint might not be perfect, and I don't think anyone's advocating for an exact copying of that with legal insurance. But the idea that law and the delivery of legal services is so different than the delivery of medicine that we can't have a situation where non-lawyers, so-called non-lawyers, share in the profits of the delivery of legal services is absurd.
I'm not saying that.
Okay, well, it appears that we have quite a variety of opinions about 5.4. Kevin, you had the floor. Do you want to move anything?
Move to adjourn.
Kevin, try to adjourn for lunch. That was a good move.
Cookies and milk, okay.
So actually, he is right. There is a motion on the floor, moved by Kevin, seconded by Dan, to look at Alt 1 of 5.4. So I, in light of the subsequent discussion after the motion, I suppose the mover can withdraw it or can.
I'd be happy to withdraw it unless people want us to pursue that or pursue all two. Again, I just think all two is going to fall in the face of the Jackson case. I don't mind working a little bit more. I've been frustrated before in rule drafting. I don't mind working on it a little bit more and bring something back for the next meeting, and we could vote it down then. Or just, recognize, let's see if we can come up with something. If for no other reason, it's something that we could leave for the implementation committee to look at, and they could make a decision as to whether it's something they want to pursue.
Yeah.
Just a suggestion. So the Rule 5.4 in Washington, D.C. has come up a lot, okay? And that rule has been in existence for, 25 plus years? What I've yet to see is, at least from the documents and discussion I've seen so far from this group, is has someone gone in and collected data about, I'm hearing anecdotes, right? I'm hearing stories of these folks going there, Big Four, going to DC, but has someone actually sat down and collected data in DC about issues of access, about issues of professional responsibility, about increased discipline rates? Is there anything out there? And if there is, I would love to see it.
There is, yeah. In the UK system, there hasn't been more complaints for kind of legally trained individuals when they rolled that out. I think that would be probably even better than just one state because it was the whole country. And there has been those types of pieces of research available. I can get you.
Yeah, I'd love to see it.
Mark.
Well, responding to your question about DC, the DC rule was amended for lobbyists because there's so many lobbyists in Washington DC.
Your mic's not
Justice.
It's really hard to hear.
Put it closer.
Oh, I'm sorry.
Put it closer.
Oh, sorry.
Oh, there you are.
So it was done for lobbyists, and it hasn't worked very well. There are some firms, but because you've got Maryland and Virginia nearby who don't have that role, it has very limited. Very few firms have really done it. I think the Big Four actually, and I just had a case involving one of them, I'll remain nameless, they had a malpractice case based out of Canada. They do much better in Canada on their system and then have some inroads here in the United States in that way, not through DC. I'm not familiar with attorney firms doing really big business in DC, but it's because of lobbyists, basically. And it hasn't, there's certain firms that it benefits and certain firms that doesn't benefit. But I don't think you're going to find a lot of access to justice data on the DC model.
No.
And on the UK model, of course, it's an entirely different system of justice, so it's hard to equate the two. But and we can get that data, but the attorney-client relationship is very, very different in the United Kingdom and the United States.
I just think this goes to, I think, a comment that was made by Andrew, who's, take care, is just about how
Hi, Andrew.
sometimes I find ourselves in this kind of situation where it's show me the data to do this, but I can't show you the data for kind of why things are in place. So one thing that I think we all can agree on, there's a lack of data in law.
Absolutely.
So we all agree on that, that's great. There is an access to justice crisis.
Agreed.
The current way things are being done is not working. In other industries, a way that has seen an increase of access to certain services such as banking, finance, and in medicine has been a tiered system of the delivery of those services with kind of a certificate program along the way. Is that something we all agree with?
I'm not sure I understand it.
So in order,
Practitioners.
paraprofessionals, nurse practitioners, MD, so for example, like when you go to a doctor, the surgeon doesn't take your blood pressure.
Right.
In law, the surgeon takes your blood pressure.
No,
And he signs the bill, and he works on the bill.
Well, we have paralegals, but they can't do everything, Mark. In which way is that not true?
non-lawyers, non-lawyer assistants, paraprofessionals do a great deal in the legal field. Great deal.
I'm not trying to downplay the effect that they have, but I think they're extremely limited in what they can do.
They're under the supervision of a lawyer, but under that supervision, there's a lot of very high technology people and engineers and all kinds of professions that work hand in hand with lawyers all the time.
But we're also seeing in other professions where those paraprofessionals are able to operate independently. So you can have a nurse practitioner set up a clinic and run a clinic and own a clinic, where right now you can't. A nurse practitioner can co-own a medical practice, where in a law firm that can't happen.
No, but lawyers can have law-related services with AI and technicians, which they're doing right this minute, to do everything but render the legal service itself, just like doctors do the operations. So it isn't true that you cannot have lawyer and non-lawyer owned businesses that provide a large variety of law-related services with law firms. That's going on right now. The question, and I think if you don't mind, come back to the cardinal issue. We need to examine what UPL is. We need to push the envelope and move the needle in the area of access to justice so that more non-lawyers can give advice and assistance where it's needed in areas of critical need. If you solve that problem and allow more latitude in that direction, then we're not going to have, we'll still have this debate, of course, but it won't be as critical. You'll have made some progress in terms of getting this segment of our population answers to legal questions. It starts with a UPL issue, and I think we ought to be hitting the UPL issue very hard. And then these rest of these things follow. Yes, well, you could change 5.4, but you've got to do it in light of, okay, what is the unauthorized practice of law? My definition is, what's the authorized practice of law? And how can non-lawyers do more in this area? And our rules of court, they can do it now. And you know, these immigration consultants, the bankruptcy consultants, the landlord advisors, all these people can do things as non-lawyers. We need to expand that in certain discrete areas of critical need. And when you do that, then you can have a conversation. It's okay. Now what's next? That's how I would look at this issue.
Joyce, did you want to?
I just wanted to respond in two ways. One, we had a discussion this morning, which unfortunately you were unable to attend, where we talked about expanding the ability for individuals to provide greater range of services based on sort of the activity model that you were kind of the proponent of at the last meeting. But the other thing I will just say, that is a way, but I really honestly believe that technology is the provision of services through technology scales in a way that a one-to-one relationship simply does not scale. And I also believe, and I'm going to Heather, I'm going to continue to use that example. The name change, gender marker change tool is something that a lot of lawyers don't do because it's very transactional. It's not something that makes them a lot of money. You've been unable in California to find anybody. The one tool one of the tools that we created in Florida that was really, really used was used by a very vulnerable population that is not the traditionally conceived of low-income person. It's not on anybody's radar. It's not something that's provided by legal aid organizations typically. Some of them are getting into it now. But I mean, that's why I think, while I want to see both. I want to see both. Okay.
Yeah, just thinking about how to move this forward. There's a couple of options. One is a very limited tweaking of 5.4, and they're not necessarily mutually exclusive, but a very limited tweaking. I'm thinking of the fee sharing with legal services. Then there is a wholesale, significant revisions to 5.4, and there seems to be a lot of debate about that, and we're getting sort of an implicit message that the court is likely not to receive that well, absent a lot of evidence we don't have. Then there is the concept of the sandbox, and as I said before, I do think it allows you to avoid certainly the wholesale revision to the rule that seems very unlikely to reach ultimate implementation in the very near term. So I just want to revisit that for Simon and Johan, you said, Simon, that this effort would be a waste if there was not a revision of 5.4. I think it would be helpful to better understand the problems with the sandbox concept, particularly if you grandfathered the businesses in the way that Andrew identified, or there was an effort to really align the California model with what's being developed in Utah so that businesses could consider, entities could not have to try to comply with two different sandboxes and two different sets of regulation. So I want to better understand the problem with that concept because I do think it would allow us to move forward. And the only last other piece I'd say is it's difficult to respond, I think, Neil, to your request for data that proves the impact of these efforts in other jurisdictions because those other jurisdictions, including the UK and DC, are very transparent about the fact that they didn't implement reform to increase access to legal services. In the UK, for example, they're really focused on, and think it's a very important thing to be focused on, increasing access for small businesses. That doesn't have the political sway in California that it has there. In DC, I understand the same thing, that it was created for lobbyists. So, they didn't do it to increase access to legal services. But that doesn't mean we wouldn't have to set ours up here with that goal in mind. So wanted to better understand concerns about the sandbox concept.
Simon, man.
You can go
Okay,
first.
so first of all, we're using sandbox in two different ways here. The first, in specific use of 5.4, we're talking about how to create it, roll things out, and have it improve over time. The sandbox that I believe Toby was asking about that I was referring to was having legal service providers of technology come in and function within a sandbox to be moderated and quantified in their outcome. So for me, they're two different things. The challenge with the sandbox is I don't really have any faith in it actually moving forward down the road. Now, I really like what Mark said, and it did go to our earlier conversation about how to get these individuals in other roles more liberal discretion to be involved and communicate and offer advice. My only rebuttal to Mark's statement would be I'm just trying to also get them paid, okay? Because part of the challenge is, the nurse practitioner doesn't want to report to a doctor, probably doesn't need to report to a doctor. Document preparers, as much as I can anthropomorphize the concept, yes, it's a human being, but we can do that with technology, and boom, we hit, one to many, or many to many, even better. So the irony, and I'll even bring up Dan's statement about the liability agreement and that type of thing, is I can put out a product. I've got one coming out in January. I can put it out for $1 a use, $1 a use, right? And the state has a need for millions of them a year. That's it, $1. So you almost take some of those people right off the map in real life terms because we can provide a massive service. One of the things, and I'll give you a direct and specific example to California, which since our last meeting, the governor signed into law. And I'm gonna paraphrase this because I haven't gotten to read the law. I was just excited to see the headline. Starting in 2021, expungement of a record upon completion of the penance or penalty would be automatic. And it started here in San Francisco with the DA that figured out that instead of what 5 years ago cost $4,000 to go have expunged, which now if you go out and you get a package deal, you get the form online and you can file it for free, and they find out whether or not you pay $150 afterwards kind of deal, whether or not it's granted, is in 2021 it's going to be automatic because it now costs 4 cents. Okay, so I know I've been beating up the technology as opposed to the individuals, but I love the idea of clerks. Clerks are some of the smartest, hardest working people out there, and they know what you need, and they know where you're going. They know the questions you're going to ask before you ask them. The same with the librarians that I've already, fully endorsed, and same with the interpreters. But we've now got machine learning that even the State Bar of California is using to do language translation, and it's literally, I think it's a penny per 500 uses, right? So we're in such a big extreme difference that the sandbox, the way Toby was referring to it, is not only inhibiting, it's constricting. I mean, in tech, we're competing with each other. We want to succeed. We want to give a bigger product, a better product, more comprehensive product. And distribution is important and it's hard. We still have the same challenge that everybody else has, which is how do we get people to know when they have a legal issue. But we're also actively experts at doing exactly that. Whenever I hear how do we get people to know this, it's called marketing, right? And we do it all the time. And then we use Google for that, and we use social media for that. And these are the things that the lawyers, because they know what they know, probably haven't had the time to spend doing these other things. So we have marketing professionals and entire teams. So the question is, do we remain secondary to the lawyers? And first of all, the answer is no, we don't, because we won't. We just won't. It's not even an issue. But I also think that it doesn't impede the independent justice or the independent judgment of the lawyers either. But 5.4 is about how to get these people paid. And that's how to bring about innovation. And that's what technology is after, frankly. No two ways about it. But we do it at $1 a use. I think you said your target was what, $5 a use, right? And you'd be happy. At $1 a use for mine, I'm buying a bigger boat.
It's already too big.
Yeah. Gotta get to Hawaii somehow.
I don't have a single.
Did that answer your question though?
I don't think it did, because I'm not sure, sorry. But in a sandbox environment, for example, your product, when you would come and apply to be in the sandbox,
right.
You would have to meet certain criteria, then you'd be approved to bring that to market, or the $5 option. So I'm not sure how it further impedes. It would allow potentially for much more expansive relaxation of the rule if you were authorized to be in the sandbox and therefore regulated while you were in it. So
So you think of the technology sandbox, not the 5.4 sandbox?
Well, a sandbox it's open for any ideas. So I'm a lawyer and technologist partnering together. We have a business idea. We're going to have fee sharing between us. This is our idea. We're going to apply to be authorized by the sandbox, and then you have a seal that says State Bar approved, and you go run with it.
But look at what we've already got out there. I mean, I'm not even talking about me at this point. We mentioned Deloitte. Deloitte just bought 14 legal solutions companies.
I'm sorry to jump in. I think we're not talking about the same thing right now, because so for this sandbox idea, I think the question, Johan, is if you're allowed to submit your idea for an existing product or a product that you're going to create, and then you are clearly said that it's not going to be limited by time, but that there are certain triggers you can't do, which you shouldn't want to do operationally from a business perspective.
Correct, yes.
That you are allowed to and able to continue to have that service in perpetuity, right, provided you don't trip up on those things. Is that something you're okay with?
In principle, yes. That's not where I'm going to spend my time, energy, and money.
Why not?
Because there are plenty of other jurisdictions I don't need to do that for. So I want to pick up 9 jurisdictions that may equal California.
So that might be your personal decision, right? But what
I think that's pretty standard investment basis.
Johan, there are lots of jurisdictions where you can share fees with the lawyers and go into that business.
And deliver legal advice as a
I don't know.
technology platform
Absolutely,
with your
yes.
lawyers?
Which?
Where?
Well,
in the United States.
That's what we're talking about, things like the difference between a form versus a machine learning versus AI. So if you go in, for example, there's a company that we talked about, well, there's Court Buddy, and then there's the one that just did a Clio. For those who just went to Clio, who's the one doing the mutually agreed upon divorce solution?
Hello, divorce.
Right, so you go in, both parties go in, and it answer the questions, it spits out the filing, and you're done.
So just because you can do it right now, there are companies doing things that are within the gray area of stipulations. But what this would allow you to say is, I have the blessing of the powers to be that we won't face any issues.
No, I realize that, but she's not involved in the actual production of the documents. It's the technology that's producing the documents. And if all it is a stamp or a certification on there, great, I'll file the paperwork, and if it works, it works. But what I'm not going to do is come in and say, California is where I'm going to launch this concept.
Perhaps.
Because again, we're starting out at infinity and drilling down. We're not chasing, going, oh my God, if I can't do this in California, I'll never get it anywhere.
Right, I hear you. I think, I mean, that's one take. I think another take, and Dan, I think as a legal entrepreneur, there's others in the room. My take on that would be, so the biggest problem that I have with the sandbox is if you're limiting it from a time restraint or in a way that would make it so that those tripwires that I mentioned would be so at such a high standard that I wouldn't incentivize me to go into it. So, you know, provided that it hits the same or less amount of complaints that lawyers get or whatever that may be, that's what would have to be worked out. But other than that, if there's no time restraint, and I know upfront and I can tell my investors, these are the stipulations, this is the time, etc. I think you'd probably find a few outfits that might be willing to do that.
And as an approval process, I agree 100% with what you just said.
Yeah, and then, you know, in terms of whether folks go into other states or not, I can launch a product right now that offers legal advice with technology. Now, it doesn't mean I can legally do that, and I would face kind of scrutiny from the outside world, etc. So there's always the risk, and I do think it's a real risk, that if you over-regulate and you make the stipulations very high, we might find ourselves in almost like an Uber-type situation where folks will just push through without it. And I don't think that's going to happen now, but I do think as an industry, and this might be an aside, I think that might happen. I only say that to ensure that the regulations aren't that high in that case.
Okay, Dan, and then Mark, and then Tara, and Caroline.
Well, I have to say, as a legal entrepreneur myself, I would echo just about everything that Andrew's saying. I would invest for a potential market of 40 million people, 6 of the US. I would invest there. When we were sort of making the investment decision of, okay, do we go after the Utah sandbox? Do we try to launch our product in Utah and geo-block it to Utah? We didn't, because Utah is not a big enough market, but California is. And so I have to say, as long as we have the in perpetuity thing, it's not time boxed. And you know, we all have feelings about what those tripwires should be. But as long as they're reasonable, and I argue for some higher tripwires in a lot of what I've put together, I think as long as it's reasonable and it's in perpetuity, there's no reason I wouldn't invest in that.
Mark?
So to bring this to some kind of a consensus here, I think you have to recognize that from a regulatory point of view and a justice point of view, there's going to be statistical data collected on each of these little projects on how it's increased the access to legal services for those who aren't getting it now. And I don't call that a tripwire.
Or sparking innovation.
I do call that a statistical evaluation that is inevitably going to happen in the sandbox approach, so that those who are prepared to loosen the public protections of our rules, in order to achieve that objective, are going to want to measure that through statistical evidence. And if it's heaven forbid, a great product for big law and for corporate law, it's not going to make them very happy. Now, would they pull the plug on you? Maybe not. I don't know. I don't think so. I think it'd be unfair. But it wouldn't achieve the result that I think is sought to be achieved here. And we have to face the fact that it's very challenging for you to come up with innovative technology for the middle class, because unless it is a great many, just like not one to many, like one to thousands, it's not going to make economic sense. So from a pure marketing and profit point of view, it's going to have to be really a heck of a piece of technology that consumers are going to use, and going to use a lot. The $1 a thing is very good, but how many people are there that are going to want their convictions expunged at the end of probation? Not a heck of a lot. So there's problems here. We have to recognize that. There's going to be marketing and implementation problems, but that doesn't take away from the policy issue. The policy issue is we need to bridge that gap. That's why I'm here. and is that we recognize it's a crisis. We recognize we've not done our job. This is Ethics 101. This is what lawyer ethics is all about. If you can't reach the consumer, your rules aren't worth very much, are they? So we really are trying to strive for that. So I think outside of the sandbox, if I were in charge of the regulatory side of this, I would want a menu. I would want to offer consumers a menu of choices. When you do the one for many, you're going to get a certain, in my view, unbundled type of legal service that is not the same as a traditional attorney-client relationship with all of the fiduciary aspects that entails. But you can have a menu of these things that gives that consumer options and choices. So if in fact it is a bet the ranch situation where their liberty's at stake, or their children are at stake, or their parental rights are at stake, they can hire a lawyer, and that lawyer is going to give them the same attorney-client protection with those fiduciary duties as the most wealthy client in America. That's what we have to achieve in this business, in my opinion.
Okay, it's Tara and Alan and Kevin.
We've been going almost 2 hours, and I know there's been a lot of valuable input, but I feel like it's very abstract, and we need to get thoughts to paper, and I don't want to see us get to 4 o'clock and be like, well, we haven't made any decisions, and now we're moving to the next meeting, and get to March and need another 3 months. So I'd really like to start packaging the discussion into what is our deliverable.
Let's hear from these two, and I've got a suggestion about that. Alan.
I just want to throw my hat in and say regarding the sandbox idea, as a legal industry entrepreneur, I agree with Andrew, right? Like, I don't think there should be a different standard, and I think, putting some kind of cap, like, because it's successful, because somebody says, whoa, this is a big threat to the industry, like, let's make it go away, right? So I think it's more like, did this lower the quality of access, or did this have some negative impact? Absent some cap or that sort of thing, I'm open to the sandbox idea. And then just one quick response to my colleague here is that when it's that kind of issue, to access an attorney, I don't think anybody here is suggesting that you shouldn't be able to access an attorney, that the technology would always get in the way. It's kind of the opposite. Like, if it's an issue that involves your children, and maybe they're being taken away by social services because you're in extreme poverty, how are you going to hire an attorney anyway, right? So, I think we're all on the same page there. I just want to throw that out there.
Okay, and Kevin.
Okay, very quickly what I want to address, because we're talking about sandbox. And if you play in the sandbox, Rule 5.4 has nothing to do with that. I mean, you don't have to have, in other words, what you're all talking about is delivering a technological solution to a legal problem, correct?
Correct.
You don't need a lawyer. The only reason you want a lawyer is someone to front for you. I mean, if I were fronting from you, I suppose, Johan, your marketing people would make me lose the bow tie. But otherwise.
So keep it.
No way.
Absolutely keep it.
Okay, but the thing is, you don't need a lawyer. That's all that 5.4 would do. It would say that a lawyer could share in legal fees in the delivery of legal services. What you're going to have to do to enable the sandbox is either to change the unauthorized practice of law statute, or what Mark has suggested at a couple of different meetings is carve out an exception to the unauthorized practice of law, as has been done for the multi-jurisdictional practice rules here in California, that says this is okay for you to do. But that can all be done separate and apart from any effect or having any changes made to Rule 5.4. Rule 5.4 is part of the California Rules of Professional Conduct, and they are for lawyers. They regulate the conduct of lawyers. They don't regulate the conduct of non-lawyers. So, the whole discussion that we've gotten off, we started with 5.4 and we're going to this, just to make certain 5.4 isn't the big solution, isn't going to be the big solution for this, unless you want to go into practice with a lawyer and cooperate in providing legal services with a lawyer and sharing in the profits that are earned from that endeavor.
So
But-
Kevin, let me ask you, I'm sorry to interrupt, but I think we had started on this whole sandbox idea because I had the impression from Leah that one thing it might do with respect to 5.4, if you had a sandbox, was if the proposal was Johan wants to go into business with a lawyer and got approval of the sandbox, then it'd be a carve out from 5.4. 5.4 can be there and say what it says, but that if they've got this business that they can propose with whatever the regulation is, then that would be a way that they could.
That's if the requirement is that a non-lawyer has to go into with a lawyer. But I guess maybe I've misheard. I mean, some of these are talking about one of the proposals, UPL, from the UPL team, I believe, was that, or maybe it was the entities subgroup, I'm not sure now at this point, but that it could be an entity that is owned by lawyers, owned by non-lawyers, or a combination of the two. So I'm trying to address the second one, where it's just owned by non-lawyers. That 5.4 is not going to come into it. If you're going to have non-lawyers with lawyers, then something would have to be done with 5.4. But that's the only reason you would have to go to 5.4. Otherwise, if you're just delivering the legal services or legal problem solutions without the assistance of a lawyer, then under those circumstances, 5.4 would be available.
So what I hear around the table is that there's not a whole lot of enthusiasm about picking away at 5.4 in the room. And there is some enthusiasm, I think, for this sandbox idea. And so perhaps what we do is make that, if we can generally have a consensus that we will look at it, nobody's saying that you're committed forever, but that we have a team that puts together a sandbox approach that we bring back to the next meeting in order to analyze the effect of that. Is there interest in that? Yeah.
Are we leaving the client consent model out, or are we leaving the completely remove 5.4 out?
I think the beauty of the sandbox, the idea is if you're approved to be there, you can propose any model that you want to propose. So I think that's the beauty of it. You're not having to deal with permanent rule changes. You're proposing models.
And Johan, I think in terms of what we would do with 5.4, I'm not taking off the table any discussion about Alt 2, but I am sensitive to the fact that 5.4 has been around for a long time, and it's very important to the court, to the justice system, to have a rule that says lawyers aren't going to be, their professional judgment is not going to be at risk because of the splitting on fees or ownership with non-lawyers. So if that's a concern about tweaking 5.4, it would be of even greater concern to our Alt 2 version that we're talking about. And then you've got the added complexity that Kevin has pointed out with this new Jackson case, that it potentially runs afoul of that. So it would seem to me that without, since what I don't hear a lot of people being excited about this nipping away at 5.4, even though you might like the Alt 2, I think it's probably not very practical at the moment. And so perhaps going with this sandbox experiment and looking and see what it looks like on paper. We don't have anything yet, but doing something sort of what they're talking about doing in Utah may be some way to advance this ball a little bit.
My only concern about not discussing or chipping away at 5.4 is that the sandbox is great for technological solutions, but at a certain point, people need to hire a lawyer. And what I'm seeing and what I'm seeing out there is that we've got fewer and fewer lawyers going into that 1 to 10, that solo practitioner to that small little law firm, and those are the ones that are really working with individual people. So when we're seeing fewer and fewer lawyers going into that marketplace and being able to stay and establish law firms, in that model, we are going to be impacting that side of the access to justice, the access to a lawyer when they need one. So the sandbox, I think, is great for the technological solution, but it doesn't solve the problem of when somebody actually needs to get a lawyer.
Okay, Tara, and then Anne.
I think I fully support going with the sandbox and having that proposal. But like Heather said, I don't think, these are not mutually exclusive, and like Kevin said, I still think we should chip away at 5.4. Again, as I mentioned earlier, we've identified 2 easy areas. We've identified how they can make a difference. That doesn't mean we don't also want to do these other things, but why would we be afraid to do something that could be baby steps and an easy fix? Because there might be 10 different things that are small fixes that could make an impact. I don't want to give up those 10 fixes for a sandbox that may or may not be implemented, that may be not for 5 or 10 years, and we don't know what's going to happen. But with something smaller and more tangible, maybe we can start to make a difference. So I'm not comfortable with giving those up for the sake of the alternative, but I'm happy to do both because I don't consider them mutually exclusive.
Yeah, I think the sandbox idea, I totally agree, other that we have to ensure that it also goes to enabling kind of just the one-to-one enabling of kind of folks who might not have a JD, for example. So I think that it would be actually, in my mind, something that's an easier enough fix, where the sandbox would have a expulsion of Rule 5.4 wouldn't exist in that context. And that can be applied for by companies, entities, individuals. And we could then determine how many folks would be allowed in at what times. And then if there are complaints, et cetera, of those entities or individuals, then it would be clear as to what those tripwires would be. They would be removed from the sandbox and couldn't perform. But if they continue along after a certain amount of time, that would provide us, to Mark's point, with the data, to then show, hey, these are the individuals, this was the impact of it. I do think one important thing would be to not put as high, a kind of a crazy high ceiling on what we would determine access to justice would be. I think individuals providing services would be good enough without the same complaints, because I think hopefully that it would lead to a lowering of the overall cost of services. But I think that could be one way we look at this. And then we would be able to turn to the courts and say, hey, in a very limited 100 entities, 100 individuals over the last year, this is what they were able to do. This was the outcome. 3 of them were expelled. They did some horrible thing, blah, blah. But actually, if looking at the lawyer complaints, that was less than or the same as what we see with our attorneys. Next year, could we do 500 or 1,000? Then eventually lead to whatever direction we want to go. Because we all might be wrong. Maybe expanding this in the old way of doing things is just the better way, and we should stick to it. But this allows us to explore that.
Okay, Kevin, I did hear you volunteer earlier to chip away at 5.4.
Okay, I want to hear this.
To chip away at 5.4. So we'll let you bring that back to us in some fashion next time. And then if we could get some volunteers for putting together a sandbox. Bridget, yes. Bridget and
I'll go to Home Depot.
Mark.
I would recommend you take a look at what Utah has done. They have a very detailed.
I'm
Is
sure.
there something wrong with it? Is there just not good?
For sure we should
Cut,
start
paste.
with.
Yes, and I heard that they're
I'm
gonna
sending you
publish
those links
in the
to you
next
right now.
few days, their actual detailed guidelines for the sandbox. That's gonna be published in a couple days.
Okay, good.
Yeah, I agree. Cut and paste is a good idea.
Great. Glad you all agreed. That was my strategy.
And then maybe Andrew, you would be willing to take a look at it in terms of the sort of tests that you were describing?
100%. I'm happy also. Tripwires. I'm also happy to ask individuals from outside the ecosystem, like venture capitalists, et cetera, to get their tips as well.
Terrific. Okay. Do we need a 5-minute break? Okay. All right. So let's take a 5-minute break and come back in. We're on the home stretch here.
Just took 2 on the table.
5.7.
Right. Okay, now, in terms of Rule 5.7, for some reason the rules subcommittee got involved. Because Alan raised the point just throughout 5.7 at one of the meetings. He said, oh, that's something wrong. And then at the very same meeting, a separate subcommittee meeting, subsequently also addressing the very same issue. And I authored a memo on that, explaining that it would be impossible in California to simply adopt the model rule, because the model rule doesn't lacks the nuance the California faces. Right now, what is permitted under what would be permitted under the model rule would also be permitted under the California case law issues of lawyers running an ancillary business that does not involve law-related services or non-legal services. There's just a special nuance in terms of fiduciary duties that a lawyer might owe under those circumstances. Under those circumstances, that does not appear to be covered under the model rule. And the first commission addressed Rule 5.7, and after going through about 5 drafts or so, eventually the first commission decided not to pursue it. The second commission, with its constrained timeline, decided that given the experience of the first commission, the recommendation from the committee that was reviewing that just recommended that we don't adopt it. Mark had a different view. I think I had a different view, and that's been sort of emphasized during our discussion here on the task force. And I'm going to pass over to Mark to talk a little bit about why having a California Rule 5.7 would be a good idea, notwithstanding the fact that what's permitted under Model Rule 5.7 is already permitted under California law.
Okay, can you hear me okay?
Yes.
Okay, so I'll make this real simple. 5.7 is important in the scheme of things because it deals primarily with the issue of when the rules of professional conduct apply to the specific service that's being rendered by lawyers, either themselves or in association with non-lawyers. And so today, as we talked about earlier today, and I've been saying now for the last few meetings, this whole phenomena of ALSPs, as alternative legal service providers, is a perfect example of this hugely broad array of arrangements that touch on 5.7 and, frankly, violate the dickens out of it in certain applications. Frankly, 5.7 has not been picked up by every state. It's what I think it may be probably even less than half. But nevertheless, in our analysis of delivering of legal services, to have a rule that tells you when I'm in association with non-lawyers and I'm rendering a specific service, to know when the rules of professional conduct govern 100% of our activities, lawyer and non-lawyer, versus they don't apply is very important because there's a variety of ALSPs where, and I can give you lots of examples if you want, where these are clearly law-related services, not legal services, and the rules do not apply. You do not have to worry about 5.4. You don't have to worry about fee sharing. However, the rule, when it was adopted, did not have access to justice in mind. It was for a different reason. It was for the fact that lawyers are teaming up with non-lawyers to provide law-related services, document productions and all that kind of stuff. Or you might have someone that renders title services or accounting services or something else that's an adjunct. Some people call it ancillary business services. So that's the reason why the rule came into place, to tell lawyers, when do I have to know that the rules of professional conduct govern this activity, and when do I take precautionary steps to make sure that my services are distinguishable enough to the consumer that I'm not bound by the rules. All these barriers to practice are not going to apply to that form of service. Here's the reason why we need to tinker with this rule. Because it defines the term law-related services. Now, just listen to this. Under the ABA model rule, the term law-related services denotes services that might reasonably be performed in conjunction with or in substance are related to the provision of legal services and are not prohibited as unauthorized practice of law when provided by a non-lawyer. Now, you can take that last phrase in light of all of our discussion, and you can tinker with that. You can come up with perhaps a more modernized, a more user-friendly, a more practical definition of law-related service. Because the point of this is to and this in my mind of thinking, this goes with the UPL definition. You know, where do we want to move the needle in terms of what is UPL versus what is authorized practice of law? Here too, you could pass a rule that gives good guidance to both lawyers and non-lawyers as to when is this activity we're going to be selling to consumers fall within the rules of professional conduct, and when does it not fall in? And we can distinguish it in a way, if we don't want to be bound by the rules, we can do things that stay out of the rules. That's one benefit of having a rule, and have some guidance there. Secondly, you can take this last phrase and maybe tinker with the definition. I don't know how you would do it, I don't have the magical language, but it invites us to take a hard new look at that definition of what is law-related services in a way that perhaps expands the nature of services that consumers can get through non-lawyers in a law-related service arena. So ALSPs, as I say, if you take a look at, you just go on the internet and search that term, you're going to see everything from soup to nuts. I mean, just the most benign law-related service to some really outrageous and aggressive ways that lawyers are teaming up with non-lawyers. I think we should take a look at it. At least not this commission, but the next task force. I think that would be a valuable task, and so I recommend we make that recommendation.
So is your suggestion that we make any effort to tinker with it as this committee, or is it simply to say that we encourage somebody else to look at it?
Well, I would love to take a look at it, but I think if you want to be consistent, you're already going to have a second commission look at the triple LTs, right? You're going to have, I don't know what your plan is, but it doesn't bother me if you want to say a commission should be formed for the specific purpose of taking a look at whether or not we should have 5.7 and what it should say. I think that would be a task force. It could be a separate task force and do that.
Yeah, so I'm just having trouble looking at this in the abstract. Could you give me an example of a problem, a specific problem that the adoption of this model rule 5.7 would solve or fix or alleviate?
Right now in California, in absence of this rule, we have a very old ethics opinion. Actually, we have two old ethics opinions. We have a new one that's come out for public comment by the State Bar Ethics Committee, which has caused a lot of furor. It's not been overly embraced. We don't have very much in the way of case law. So if I'm a practitioner in the field and I want to team up with you to deliver a portal of automated services that I think I can distinguish from legal services and share profits with you, I'd be benefited by knowing what this rule says.
I see.
And it also might curb some of the abuses that maybe some of you see going on in the field of ALPS, where I have one right now where the law firm is 100% operated by the non-law firm. Everything, soup to nuts. Every nickel, every dime, every function is in the venture capital firm. All the law firm does is get paid a salary for running legal services, and all the profits goes to the other firm. You might think there may be some issues there, but it's happening, and it's been talked up, and it seems to be a good idea for many people. But in my judgment, it has some influence on your independent professional judgment. But a rule, however you want to write it, I think would be helpful in the scheme of things. It plugs a hole in this exercise of how we get services, more services to lower income people. I don't see many disciplinary cases. I mean, you do. Let me say this: you gotta in your own mind distinguish between dual professions, for which the state bars come down hard on lawyers. If you're in a dual profession, like I'm a lawyer, I'm a real estate agent, I'm a lawyer, I'm an accountant, you are perforce bound by all the rules with respect to 100% of your services. That's not what we're talking. We're talking about law-related services, such as engineering services, environmental services, accounting services, maybe document preparation services. That and I have clients that design software programs for their clients through a separate company. I have one that will remain nameless, a very famous law firm that designed a whole HR online program for all HR people that tells them all the law on all employment issues that might come to their attention. They don't have to talk to a lawyer at all. This separate company buys it, sells it, markets it, uses it to get business, of course. And then when it gets serious, they can call a law firm for some legal advice. That's a law-related service. And if you do it right, it's perfectly fine. The question is, lawyers can step over the line, and so I think it's useful.
Andrew?
I just wanted to follow up on a comment Mark made about a recent ethics opinion that was out for public comment and for the benefit of the task force. And when the memo that Kevin and Andrew produced for the task force regarding 5.7, a copy of that opinion was in the materials, so you may have read it. But following public comment, the committee has decided to table that opinion and not developing it any further. They were aware that this task force was thinking about a 5.7, and I won't speak for the committee, but I will say part of the conversation was it'd be helpful if there was a 5.7 in California for which they could base their analysis and conclusion. Part of the problem is case law and Supreme Court case law is very clear. When a lawyer is providing services in a fiduciary capacity, even if he's not acting as a lawyer whatsoever, the rules of professional conduct apply. And it's difficult to carve out an exception as an ethics committee for clear Supreme Court precedent on that issue.
Okay, is this a recommendation that we can write up for the next meeting and people can see what it says?
I think so. I wonder if it's, usually we're looking for it to be articulated as some sort of implementation or action plan. What do we want to do with 5.7? Is it really just take another look? I think we could probably say more. We do have what was in the draft ethics opinion. One of the comments that came back in that led to COPRAC tabling it was a nice long comment from the Office of the Chief Trial Counsel that really represents some of their distillation of the existing law. And we also have what the most recent Rules Revision Commission did with 5.7. So if we can package that for the next group, then I think we give them a leg up in terms of getting it right.
Okay.
Yeah, but Andrew reminds me that opinion came out and it talked about fiduciary obligations and all that. That's a complicated issue, and I didn't mean to suggest that was solved in this rule. So it has applications that can be quite complicated. But yeah, I think we should package it up but unless you want, I don't think we can really do a good job on this, Kevin, within now and March of this year. I think that takes a good hard look by a task force. It can be 5 people, or whatever you want. But I think it deserves study. I'm not sure you can do a good job in 2 months.
Joanne?
I'm thinking that maybe we ask just the Board of Trustees to look at the rule instead of creating a form of the commission or passing it on to the next group, because the board has the ability to look at a rule and get recommendations from staff on how it should be revised, and just try to reduce the number of committees. I'm not sure it's necessary. They may decide they want to do that, but I think the recommendation would be to ask them to do it.
Kevin, then Tara, then, did you have your hand up?
No.
Okay,
No, I'm good.
you're okay, Tara?
I guess I just wanted clarification on whether we're going to make any recommendation, or whether we should vote on whether we want to include a recommendation or not include a recommendation that relates to this. Like, do we even want to evaluate it further, or do more write-up, or, I don't know.
So we can certainly entertain a motion that we ought to write it up just purely for packaging it and sending it on to make a recommendation to the board of trustees. We can look at it at the next meeting. If someone wants to make a motion, we can vote on
Can I
it.
just make one quick comment? Joanne makes a good point. Typically, that is how the rules are developed. The board can absolutely direct COPRAC or any other group or staff to develop the rule. I'll just say, speaking for myself personally, looking at this rule from an access to justice lens, I thought it might be helpful to have some of the input of the folks that are here today. Now, that's not to say that you have to come up with a rule yourselves and deem it approved and recommended for the board for approval to send the Supreme Court. And I don't want to make Mark or Kevin do any work or anyone else around the table. But if there is a phrase that's troublesome, and you had the opportunity for this group to look at it to see how it might address some of these critical issues that, as a group, you are all striving to solve and achieve for the next implementation body that will actually draft the rule. Speaking for myself personally, that would be really helpful to take with us as part of the materials that you're packaging together.
Mark?
Yeah, I think in fairness, the people here have not even seen this rule and don't even know what I'm talking about. I think for the next, I don't think you need to vote. I think for the next meeting, we ought to put on the agenda, having the rule and some background material and perhaps some suggestions about how it can be recommended, so that everybody in the room is on the same page and can read what we're talking about, and then they can make an informed decision.
We've already had a memo, so I think that's already.
Oh, you did?
I don't,
Yeah,
yeah,
there's-
so
okay.
it's already been done and out there.
Okay. Leah?
I guess I don't see the relationship to increasing access. I in the Lucy Rica white paper, about a third of it is dedicated to ALSPs, and it's fascinating and, just eye-opening to see what's happening and what essentially seems to be completely unregulated. And I think there is perhaps a problem there, that you have, like, on the corporate legal side, all this stuff going on unregulated, and then we're talking about trying to open things up on the people law side and imposing a lot of regulation there. So I see it from an equity perspective, and maybe you want to do something, but I guess I'm having a hard time seeing how advancing 5.7 increases access.
So if you buy the idea that we would tweak the definition of unauthorized practice of law, we would change it to some extent to allow certain things to occur that are not currently authorized, you move that needle. Then this phrase on what denotes law-related services for purposes of this rule would also change, so that there could be certain activities that allow for the combination of lawyers and non-lawyers in a single entity, sharing profits, all that sort of thing, that does not come within our rules. Because the conduct is not unauthorized practice of law if performed by non-lawyers. That's what I have in my mind. So suppose you took document preparers and expanded that to allow them to do 5 or 6 more things than they're doing today, giving them some level of advice. Suppose you had lawyers who have this great, the lawyer brings to the table a lot of expertise on how to, design this product. The high-tech people come in with all of this technologies on how to present it in a fair way. You could have an entity that shares the profits, investment. The rules don't apply. They're not governed by the rules. Now, I can't do more than, I can't put meat on those bones, I don't know what we're talking about, but it seems to me that gives you another, it's not another avenue, it just gives you another feature to protect this investment by the non-lawyer saying, look, I don't want to be accused of, and the lawyer says, okay, I can do this and not worry about all these dues of loyalty and confidentiality and all this stuff because it's a non-legal service. That's what's really doing it. Now, will that work? I don't know, but it's worth looking at.
Okay, Kevin and Johan.
Yeah, I'm just a little bit concerned. I think we need to look at this pretty carefully because if we keep this definition that they have, and they say that they are related to the provision of legal services and that are not prohibited as unauthorized practice of law when provided by a non-lawyer, then there's still services that the non-lawyer is providing that are legal services, correct? Wouldn't they be? Couldn't they be?
Well, they would be law related.
Because if we're talking about carving out more exceptions along the lines that has been done for multi-jurisdictional practice, so that we're essentially MJP statutes or rules say this conduct performed by these particular people who have satisfied all these requirements are not the unauthorized practice of law. Essentially, that's the position that we're taking. Yet they are providing legal services. And if the lawyer is joining in providing legal services, even though it's not viewed as not unauthorized practice of law by a non-lawyer, it's still legal services by a lawyer. I think we have to take a close look at this definition.
Johan.
First of all, I really like 5.7. For me, 5.7 is doing for lawyers what we talked about in our tiers in doing for non-lawyers to bring them into the market. It creates the middle ground that is the law-related services. It's not necessarily the practice of law. That's got a whole different threshold than law-related services. So this actually gives us 3 tiers. It gives us the practice of law, the law-related services, and related services that are not law-related. So this builds the middle ground for the lawyers and the other than lawyers to meet, in my mind.
And you get back to the irony of this. If a service is performed by a lawyer in a law firm to a client of the law firm, it can very well be the practice of law. If you take that lawyer out of the law firm and put him into a law-related entity, it could be a software company or some high-tech, and produce a similar service, but not as a lawyer, but as an entrepreneur along with other investors, it might not be the practice of law. We have lots of examples of that, of lawyers engaging in conduct not as a lawyer and not in a representational capacity. They do it all the time. And I realize we're getting a little esoteric here, but you could create a situation here that protects the ability of lawyers to team up with non-lawyers to provide services to consumers that would not be considered covered by the rules.
Okay, so we won't take a vote on this today. Why don't you bring something back to us and we'll take it. Staff can bring something back to us. Terry, you okay with that?
Sure.
Okay. I think we are now moving on to the next agenda item. We have 20 minutes. We're not going to go over, but Randy, why don't you take us as far as you can on B3, the general recommendations.
So one of the general recommendations, and I mentioned it earlier today, is maybe an easy one, but now I've jinxed it, is this recommendation 3.0, and it was one of the 16 options for regulatory reform, which was the adoption of a new comment to our competence rule that would state that the duty of competence includes a duty to keep abreast of the changes in the law, including the benefits and risks associated with relevant technology. And it's a comment that is part of the ABA model rules. The last Rules Revision Commission did not adopt it, in part because there are a lot more detailed guidance in a series of ethics opinions. But the subcommittee that looked at this found it to be helpful to consider including, because we do want lawyers in traditional practice to also be optimizing efficiencies through the use of technology. So including this was viewed as an encouragement to lawyers and law firms to use technology in a competent manner. Now, we did get, I think, one negative public comment point back on this particular proposal, which was that the way it's phrased, keep abreast of technology, might be a burden to two particular groups. One would be the solo practitioners trying to focus on keeping abreast of the law that they practice, let alone having to keep abreast of technology. And so they didn't like it as a proactive, must be knowledgeable standard. And then the same type of criticism was made with respect to perhaps elder practitioners who are avoiding technology because they feel they're not really competent, they're not digital natives. So asking them also to have a rule of professional conduct to keep abreast of it was viewed as an undue burden on them as well. Now, the reason why I don't see those as particularly persuasive criticisms is because of the way our competence rule is written. Unlike the model rule to which this comment is attached, the model rule says, thou shalt be competent, render competent services. But the California rule, even after the last go-around with the Rules Revision Commission, what was adopted effective November of last year, we remain a thou shalt not rule. And so you're prohibited from rendering services that are either repeated, reckless, or intentional, or with gross negligent incompetence. And I don't think that the two criticisms we have would ever be triggered under our actual black letter rule. You'd have to be really, really reckless with regard to use of technology in order to be, I think, subject to a competence violation under our rules. And if you are really, really reckless, I think it's an appropriate investigation of that particular practitioner. And so you use a device at a public Wi-Fi that is not encrypted and your client's information is now irretrievably lost or the privileges has been impaired, that would be an example perhaps of something that was either grossly negligent or reckless to do, particularly under the ethics opinions that are out there right now. But if you're an elder lawyer who doesn't use technology and you don't know, what's that standard you referred to earlier,
WCAG.
You know nothing about that, even though it applies to your website for disability access. I don't think anyone's going to charge you with a violation of the competence rule, because I don't think that hits the level of reckless, repeated, or intentional or gross negligence. So if you're not moved by the two negative parts of the public comment and you think that adding this is something that we can support to the board, then it would be a recommendation to include in our final report. And it might be that out of abundance of caution, if there is another body that will have a more nimble rule drafting membership expertise on it, then one thing we could do is suggest that any of our rule revision recommendations go to that body as sort of a way of assuring that it's getting the attention that it deserves. We really can't serve these things up, even something simple as this, for adoption, because it really wasn't issued for public comment as an actual proposed change in law. This was an illustration draft of the concept of requiring, as a part of the duty of competence, to look at technology and understand technology. So before the board could even have it on their agenda for adoption, it needs to go out as an actual draft rule prepared by somebody. And so our recommendation would just be that something along these lines be developed and be considered for board adoption, perhaps by some, again, more nimble rule revision body that would be looking at all of the task force's rule revision proposals.
Does anybody want to make a motion?
So moved.
Second.
All right, the moving second, any discussion? Okay, let's take a vote.
Andrew Rita,
Abstain?
Samuel Boney,
Yes.
Tara Bird,
Yes.
Judge Wendy Chen,
Yes.
Abhijit Sivan.
Abstain.
Yes. That was an abstention, right? Abhijit?
Go ahead.
Jean Clausen? Johan Drolshagen?
Yes.
Margie Estrada, Lori Gonzalez, Bridget Grammy,
Yes.
Andrew Kuchera, Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Ruby,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rivers,
Yes.
Mark Tuttle.
Yes.
Streamers.
Okay, Randy, you think we've got time for another one, or should we wrap it up?
We can wrap it up. I did have at the end of the agenda the reference to some things that we already touched upon. It is the D section of the agenda. D1 is the survey of the public, and staff might be contacting people who were volunteers before to work on the survey, and we'll talk about that with them. And then D2 is the outreach, and as those things get scheduled, again, we might be tapping into some folks. But I don't think we have enough time to dig into any other actual recommendations.
So get Mark.
Where are we on the advertising rules?
We did not discuss them today.
I know, but I mean, in general. Are they on are they gonna be on an agenda?
They are on the agenda. They were on last time, this time, and I think we might be actually moving towards getting to them next time.
Okay.
So let's talk just for a moment about timing. This is really tricky because our next meeting is January 10th, and we've got the holidays obviously in between. We've talked about various original drafting jobs, teams that are going to go to work. One thing that would be helpful is if the teams could do your initial draft by December 23rd. So in other words, it's like a week and a half, by the following Monday. That way, they can then go out to people for comments. The comments can come back in right after the first of the year. So let's say January 2, we'd like comments for folks on the stuff that are sent out for comment. And then we'll get staff to wrap up everything by the time that we get back here for our January 10 meeting. So it's a really tight schedule, and I apologize for that, but in order for us to really make good use of the January 10 meeting, I think that's best. Joyce.
And I wrote to Randy mostly to make sure it made it out of my head, but in the very beginning of the meeting today, Randy had a conversation where he talked about, the final report and drafting of the final report, and there were sort of these three components, the pros and cons and the this and that. And I don't remember all the three components, one, so I'd like to know what those are. And two, if you have a format, I know that you said the staff would do the window dressing, but it would seem to me that Tara and I worked pretty well together, but I know there's going to be some transition between what we've been doing in sort of memo form to what it needs to look like in terms of the final report. And even if I couldn't fully complete everything that was on the format, at least if I knew what was going to be on the format, my guess is Tara and I will be continuing to sort of shepherd this through until we get to the point where we're done. So the sooner you could give me a format that kind of a go-by that says this is what we're going to want to see once we do the final report, it would just be helpful. Because then we can just get in front of that for you rather than continuing to write in this memo format, and then there's going to have to be some point where now we have to move everything around or whatever.
Okay, I can talk with other staff about
Okay.
what might be the best format, because in the past we have the Rules Revision Commission materials that went to the board and went to the court. We have the MJP stuff that went to the court from the advisory task force. This might be slightly different, particularly when you're writing up a proposal for something that's not an actual change in the law, but is a sandbox approach or something. So how you present that might be a little bit different. Maybe more so it's the Utah version that some people have referred to. But I think Lee and I can talk about how it can be packaged.
The if there's a piece of that we're not currently thinking about that's gonna be required or needed as part of the final report, it would be nice to have it sooner rather than later. It's basically all I'm saying.
Could you give me the date for the comments? You said
Yeah, December 24th for the first round.
23rd.
I'm sorry, 23rd for the first round. And then the staff will send that out for comment, and then we want comments back from everybody to what's sent out by right after the first of the year, January 2.
And when we send out the assignments soon after this meeting, it'll have all those dates in it. And one other thing is, for those folks who are working on assignments and you're emailing each other or emailing staff, please copy the ADLS box, because we want to keep a comprehensive record of communications in case we need to refer to them or produce them. Joyce, you talked about the other traditional components in support of recommendations.
Yes.
The pros and cons is one that the task force staff has asked that we be sure to include. The other parts are how the recommendation advances the charge of the group, and so what is the expected outcome or results of the proposed change in policy or law. It has to be pretty explicit, and then the alternatives to the recommendation that were considered but not acted upon, including anything that came into the public comment that seems perhaps superficially to be a better alternative, but was not adopted by the task force. And so if we have those three things in the report, that usually gives us good support. And in this particular context, I think also including anything we can in terms of data or results of any of the Justice Gap or other surveys that we've looked at is probably a help, as well as the two reports, the Henderson and now the RICA report.
I'm challenged by the pros and cons aspect of it, because all of this is stuff that hasn't been tried. Everything's speculative. You're having to guess what the pros and cons are gonna be without any data to support it. So I find it very challenging. You kind of have to make up, okay, what's the good things? Well, you think the good things are gonna be this. What are the bad things? Well, some people say the bad things are gonna be this, and we don't have any data to support it.
Yeah, I don't know if the pros and cons have to be objectively verifiable assertions. When we had the Rules Revision Commission exercise and we submitted pros and cons for every substantive change we made in the rules, some of them were just what we surmised might be a con, and I think that's fair. It is speculative, but it's better than leaving it to the court to imagine what would be a con.
Yeah, we engaged in a liberal use of the word should.
I don't like it, and I'm not promising that I'll be able to do all of that. It'll help if that's the expectation.
Sure.
So folks, thank you so much. Happy holidays to everybody, and we'll see you in the new year.